Absence of the lordship, mother, 5 years for 4-year-old child lordship, and without considering the direction passed by your lordship for modification. 52 lordship.
Yes.
At 12 lordship.
Let me see. You remain. I can call it prior to that also.
Lord, may I be permitted to?
Item number 53, your lordship, today's
53.
my lord.
Yes. What is the urgency?
My lord, in a suit for declaration.
What is the urgency?
My lord, may I, my lord. Suit for declaration permanent injunction, recovery of possession. There is an injunction order. Without varying or modifying the injunction order, there is a application filed for repairing of the suit property. That was, my lord, allowed.
53.
53, my lord.
All right. Yes.
Great.
May I be permitted to
Please
mention?
wait. Let
My
me
lord,
see.
I shall.
Leave to move this matter before the vacation bench, my lord.
Yes. Which item?
Lord, it was appearing as item number 128 in yesterday's list. my lord.
Yesterday's list.
Yesterday's list.
Leave to move before the vacation bench.
My lord,
Yes.
shall I hand over the slip or it will come? Shall I hand over the slip or it will come?
53.
My lord, I am seeking leave to move these two civil revisions before the vacation bench, my lord.
Leave granted to move before the vacation bench. The matter is appearing in the list.
No, my
Where
lord.
is the file?
My lord, one of the matters was appearing in the list yesterday.
That can be granted. Where is the other file? Unless the file comes, how can that be granted? Where is the file? Yes, call the list. Yes, call the list.
For judgment and for what?
For all the reasons as aforesaid, CO 924 of 2024 stands allowed in part. Yes, call the next matter.
Item number 2.
I approve the respondent.
For visitation, I think I could not reach my own time, my lord. Item number 51, if it could not taken up.
Item number
54 month. Okay.
52.
54 month.
54.
51. 51. 51.
You do not know which item.
Plus,
You are mentioning all the items. 51. Note code 51. Yes. Yes.
My lord, I am appearing on behalf of the opposite party.
Lordship, I appear for the petitioner.
Yes.
16-9.
Lordship, I am filing the written notes, Sir Lordship.
Why it is appearing as
We are
filing
directed
the
to file
written
the
note?
written note.
This is the volume of the written note.
They have compiled. It has been compiled. The cases have been compiled, Your Lordship.
The written notes of argument filed by the petitioner is taken on. Extension,
Extension.
have you served upon the other side?
But has been returned to the sender, that is the postal tax.
When the service is not complete, the learned advocate appearing for the this is application tool. Yes. Passover, next. Yes. Passover,
Six.
6, you are appearing.
Yes.
You have not responded. I thought one is appearing. Din 6 ta din.
My lord, in this case, I am appearing on behalf of the petitioner. I am seeking for spot accommodation. As the recorded address is suffering from fever.
You want time?
Yes. After opening any date,
Not today, next.
I am.
Not today, next.
Well, in this matter, Jonathan Mondor for the petition, well, he could not come today after vacation.
Not today, next.
My lordship, item number 9, 10 and 11, I am led by Mr. Animesh Paul. He is engaged in another court. Kindly makes it not today.
Not today. 9, 10, 11, next.
That
You are appearing.
I am appealing for the petitioner.
Yes.
A very short case. But one thing, my lord, I mean the defendant in the court below, defendant number 2, defendant number one of the defendant number 2. I'll kindly give me 1 minute. Very hurriedly, my lord. My lord, defendant number 2, original defendant number 2, your lordship will get the plain, page 17.
Yes. What happened? What is the impugned order?
My lord, the defendant number 2, he died, intestate.
Yes.
Died, he is a tenant, and the one partnership firm is the also tenant, they are the partners. Likewise, the suit was going on. Then when the defendant to Rajesh Samdar died, the plaintiff took a plea that I am a bachelor, and in spite of my submission of the death report, I am a bachelor, so no legal heirs to be represented. At least one partner is there. At least as per the partnership under chapter under order 30, your lordship.
What is the impugned order? Which order is the
Yes.
impugned order?
Impugned order is that my last page.
3rd of July. What has been done by this?
By this, I made an application under section 195, 1B of the read with section 340 of the CRPC that there is a deliberate misstatement, and you take note of that and take cognizance. Without taking any inquiry, the application has been disposed of. The court should have taken cognizance also. That is the only. Unless, my lord, one of the another partner will be party. If not my legal heirs are also
Petitioner is
partners.
directed to serve a copy of this application by
Yes.
registered peoples with
Gratefully, lordship.
pass over next. Pass over next.
So I am for the petition in this matter, Your Lordship.
Yes.
It put for declaration permanent injunction, Your Lordship. In the connection of the suit, Your Lordship, I have filed one application under Order 26 Rules 9, Your Lordship. That application was rejected. Against that order of rejection, I am before Your Lordship. Kindly, Lordship comes to the impugned order. Kindly see, Your Lordship, the reason of refusal of my application is the reason why in Order 9 Rule 7 application, which was filed by me prior, that was the reason which has been stated. The matter was not gone into the merit, and Your Lordship, the matter was dismissed. Application was dismissed.
Where is your application? What is the where is the plaint?
Plaint is at page number 13, Your Lordship.
13.
Plaint.
Where is the application under Order 26 Rule 9?
Lordship, that is at page number 32.
32.
Sorry, Lordship, that is at page number 27, Your Lordship. 27.
27.
Maybe stand corrected.
Yes, where are the points of local investigation?
Lordship, that is. Lordship, I have
This
stated in my
application under
prayer, Your
Article
Lordship.
227. Yes, this application under Article 227 of the Constitution of India.
The lands
Yes.
are adjacent, your lordship. The lands are adjacent, your lordship.
Maybe. Yes.
And they're trying to encroach, your lordship.
Appearing for the petition. Lord, suit is partition suit, my lord. And the status quo order was passed, my lord. Against that, I filed on means appeal, my lord. And the means appeal, I was also lost the means appeal, my lord. Against that order, I have come before your lordship, my lord.
No, where is the order of the trial judge? Where is the order passed by the learned trial judge?
That is page number 75, my lord.
Temporary injunction application was allowed.
Yes,
What is the suit for?
suit for partition, my lord.
Suit for partition.
Lord, what I am saying, Lord,
I am expediting the suit, sir.
no, my kind, bear me. Four deeds are executed. 4 deeds are executed in favor of 4 sons, including me, Lord. And I constructed one-story building in the year 1998 by obtaining permission from the Panchayat authority. I started to make construction again on the first floor after obtaining permission from the Panchayat authority. When I was started construction, Lord, this suit is filed just to start my construction, Lord. That is, so I was in position. I was in possession of the portion of the unpartitioned property.
That has not been disturbed.
But-
Is the existing possession status quo has been directed to be maintained. So your possession has not been disturbed by the impugned
But
order.
they are the police authority has obstructed me from making construction.
No, so if you have to make construction, you have to take permission from the court. You have to pray for modification of that order.
That was rejected. I also made it.
Where is the application for modification?
That is
Where is your application for modification, sir?
that was disposed of with the application for injunction.
Show me the finding of the learned
I
trial
will
judge
see.
with regard to the application for modification. Show
That
me.
is page number 75, my lord.
Page number?
Page number 75. my lord. That is order that has been mentioned in the order. The application filed under order 39 rule 4 151 and this search and search by given number was according.
Where
to
is your application under order 39 rule 4? Show me that.
that has not been annexed, my lord.
That's the only relevant application and you have not annexed that.
Yes, not that I made application and that was also rejected along with the rejection of application.
The learned advocate appearing for the petitioner submits that the petitioner is
No, I'm appealing for item number 5. I'm appealing for the petitioners, my
it
lord.
has been passed over. Yes. Call the next matter.
I appear for the petitioner, my lord. The petitioner is a defendant in the court below, my lord. Suit for eviction. Decree was passed against me. Preferred an appeal, my lord. In the same appeal, my lord, we have prayed for
Occupational charges.
occupational charge. But kindly visualize, my lord. 190 was the occupational charge which they have accepted. It was enhanced to 6,000 per month. Tarokeshwar, not in Kolkata, also, my lord.
Maybe. What is the extent of your accommodation?
Only
What is
50
the
square foot, a shop room, my lord. Only two. In
What is the nature of the business you are running there from?
tailoring business.
So now,
Ladies tailoring business. Well, it's not kindly.
lucrative business, Mr. Vadajaji, during the festive season. Diwali is also coming.
He's not in Kolkata. Kindly visualize, but they have accepted 190 rupees.
Mr. Vadajaji, what is the market rate of rent there? Less than 6,000.
But
Please, less than 6,000. Please fetch an accommodation. Please vacate.
Kindly visualize.
Mr. Bhattacharya, I'm asking you, have you taken it?
Other shop rooms are also on the same.
Maybe I'm asking you, you have suffered a degree, others have not suffered a degree. So I'm asking you, is the market rate of rent in that locality less than 6,000? Please fetch an accommodation in that locality. Please move out.
Kindly, my lord.
You did not pay 6,000. Why will you pay 6,000?
They have.
Mr. Bhattacharya, if you get an accommodation at less than 6,000,
Ranit Court Bureau has come to 6,000 without any basis. Kindly seize the order, my lord.
Mr. Bhattacharya,
Assumption, my lord.
thumb rule sometimes has to be.
Only a ready tailoring shop, no, it's not a.
Yes, yes.
And
Yes, what material did you produce before the learned trial judge for ascertain?
they have kindly seize their application at page 43.
Yes.
They presently the rent of the shop room is 10,000. The room is used by the applicant is 190 rupees. They have accepted it.
Rent 190, nobody is disputing, but after decree is passed, cannot be 190. Mr. Bhattacharya, those
seize their application once by
prior to Astaram, prior to 2005, yes.
That should not be
Decree passed after 2005, you are gone.
Also, my lord, kindly have my lord, let the appeal will become infructuous in there. Kindly expedite the appeal. I have no difficulty on that event also. The father of the applicant has also died when only running a shop room. Kindly visualize the situation of 190 to 6,000, my lord, is and
from 190 to 6,000.
Yes.
You know what was my fate there? From 1,800 to 1,80,000. From 1,800 to 1,80,000. So that was my experience there.
Kindly visualize, my lord.
So it's 190 to 6,000. You are in a much better position.
Not in, if it is one in Kolkata, I would have never supported this, my lord.
Kolkata, it should not have a 6,000. Some more zeros will be after that.
But Tarokeshwar, my lord, is
some more zeros will be after that. Don't say 6,000 in Kolkata. Some more zeros will be after that. On the right hand side, not on the left hand side. Ashun.
Kindly have let the appeal be expedited. I have no regret. Kindly reduce that amount, my lord.
You can take your own time to pay the occupation charges. Mr. Bhattacharya, I am not expediting the appeal. I can expedite the appeal. Please pay the area occupation charges.
Other area charges have been paid, my lord. These from the date of decree, 6,000, 72,000 has been fixed, my lord.
Yes. 6,000 is.
In Tarokeshwar is only a small 50 square foot shop room, my lord.
Show me any material to show that the market rate is less than 6,000.
But other persons are also giving the same 100.
When they were inducted, Mr. Bhattacharya, the other tenants.
But they all are in the same position till date, my lord.
When they were inducted, date of induction, I am asking
but
you. And date of your induction?
But 2021.
What is the date of your induction?
20. Kindly sees, my lord, in the plaint itself.
Yes. What is the date of your induction?
Same time all were inducted.
Yes, I want to know the time.
2021, my lord.
Yes.
But they have kindly seized the other occupation. One is 200, one is 400 rupees, my lord. These are the other persons who are giving the same occupational charge.
When this order was passed, when the decree was passed.
A decree, my lord, kindly see page 23, 14th of December 2023. Judgment, my lord.
Yes.
Page
14th of
December 2023.
Yes.
Annexure C.
How much amount you have paid any amount? You have not paid any amount. 190 also you are not.
No, 190 I have paid, my lord. 190 they have accepted,
yes.
my lord. But kindly seize, my lord, page 43 once. They have accepted that. Page 43, it's their application. The room used by the appellant defendants only rupees 190 per month. That I have been paid, my lord.
So what according to you is the reasonable rate of rent?
I will be humbly saying, my lord.
For?
1 to 2,000, my lord, if my lord is saying. If my lord.
1 to 2,000, you will not get any rent. At 1 to 2,000, shop room, It's difficult.
If my lord, whatever if falls from your worship, my lord, but kindly have some. So 190 rupees, others are paying, one is 400, other is 200 rupees. That's,
That don't say
I
that.
am,
What others are paying, let them pay. If you get an accommodation less than 6,000, you can move out.
is,
Yes.
but I have.
So that's it.
Now
Mr.
in,
Bhattacharjee, please ask your client. What's the market rate? You will know that.
uh,
That's the first question which you should ask when the client comes to you in
well,
this
they
type
have
of matters.
claimed 10,000 without any basis, my lord.
Your client knows that the market rate is less than 6,000. That is why he is not moving out. Otherwise, he
No,
would
no.
have moved out.
They are, let the appeals be by the hard, my lord. I will obviously by the knows
Deposit a lump sum amount of 50,000.
50,000, my lord.
50,000. I am keeping it just after the vacation because according to you is the 2,000. If it is, even if it is taken at 3,000, so December the decree was passed. So 1 year, more than 1.5 years.
36.
So 36 months into 3,000. What is the amount?
36 months.
It's more than 1 lakh. Deposit 1 lakh.
50,000, if
No.
whatever falls from your.
Mr. Bhattacharjee, I am with you on the rate, but deposit that. Deposit that. Show your bona fide. I will admit. I will keep it after the vacation.
Kindly keep 3 weeks after the vacation. Meantime, I will shall deposit because today onwards the court will also will start closing, my lord.
You will deposit 1 lakh when?
Within after 3 weeks, within a period of 3 weeks.
So the courts are reopening on 24th. So deposit by October 31. You are getting 1 week time even after opening.
May I make one humble?
Because you will be getting 2 festive seasons.
Okay.
Diwali also you will earn. This is the best time for you to pay, Mr. Bhattacharjee.
Kindly
Then
keep,
Christmas.
on November 7th, my lord. One week more.
I'm keeping on November 7,
My lord.
but please deposit by October 31.
Kindly allow me to deposit by November 7th, my lord. If my lord.
No. October
Only-
31 is the best time. Is the best time.
Well, that's a
Ashok.
kindly keeps on. I will shall deposit on 31st.
This application under Article 227 of the Constitution of India
For the petitioner, my lord.
Yes.
And the petitioner is the father of a minor child of 14 years who has challenged an order extending the time limit for visitation by the mother from 1 hour to 3 hours, my lord. The child,
Who are you?
I'm the father, my lord. My lord, the child is studying at class 9.
Maybe. Nothing will happen. He will improve in his studies.
My lord,
If
the,
he
both
meets
the
with the
mother
father.
and the father are the school teachers. My lord, kindly see the reasoning given by the learned court
Yes,
below,
yes.
my lord.
For 4 hours on first or third Saturday.
First
First
and
and
third
third
Saturday.
Saturday.
Ah.
On each month in Kandi court. Yes.
But
So you
the
have difficulty.
difficulty is that the court premises is situated far from the residence where the child is residing. Child is with the father, my lord.
So I give you, you want a different place.
No,
I give you
not a-
liberty to apply before the learned trial judge for any other place other than the
My lord,
court.
the prayer before the learned court below was to exempt the child from visiting right now because of his studies, my lord.
No,
My lord, that is
cannot be
the
done. That cannot be done. Sir, only 2 Saturdays. I was thinking of all Saturdays. I was thinking of all Saturdays. He will improve in his studies. I am telling you. You are the father. He will improve in his studies.
my lord, there are other issues also which are not before this in this matter, my lord. There are false allegations also.
This application under Article 220.
Lord, items 19 and 20, my lord, I'm praying for an adjournment. My
Why,
lord.
Mr. Chakravarti?
My lord, because
Last day.
no, my lord, the last on
Today
last
is the last day.
No, I agree with that, my lord. It is last day,
Yes.
my lord. But the issue is, my lord has adjourned 2 matters which are similar to this one,
Only,
2 weeks after the vacation.
It was directed to appear after the vacation.
Yes, yes.
But
I had
today
sought
করে
the
রাখো।
adjourn, not
Item number?
1920.
19 and 20 not today করে রাখুন।
I'm
Yes,
grateful, my
next.
lord.
21. Pass over next. You are appearing.
My lord, appearing for the petitioner led by Mr. Anand Banerjee.
Yes, yes. You want to do or you want an adjournment?
Lord,
What do you want?
He's online. I'll start, my lord.
Yes, what is this matter?
My lord, this is directed against an order of rejection of an application under of the Code of Civil Procedure.
151. 14.
Lord, may I clarify, my lord?
Yes, yes.
Lord, suit for, my lord, declaration of tenancy right. I filed claiming that I am the tenant. I am the plaintiff. Plaintiff
Yes.
claiming for declaration that I am the tenant. In the suit, my lord, I got an ad interim order of injunction on 7th of May 2025. Status quo to be maintained, which is at page 24. Then, my lord, in the same order, I also got an order for, my lord, local inspection of the premises. When
Yes.
the defendant got the notice of the, my lord, local inspection, they have put a padlock over the, my lord, locks, put a lock over the locks, my lord, which were already, my lord, put by me in my shop room. So they blocked the access. I filed this application under 151 for implementation of the injunction order. Inspection took place, my lord. The local inspection commissioner was not allowed to go inside. He has given his report that my access is prevented. It is locked, and they objected, my lord, that locks cannot be opened. That is also recorded. Then 151 is taken up. Court has rejected on the ground that you have remedy under Order 39 Rule 2A. So 151 is not maintainable for implementation of the injunction.
But Mr. Banerjee, you are trying to implement an ad interim order of status quo.
My lord, after the order, my lord, they appeared, they filed written statement where they admit that my predecessor was the tenant, I am in possession, and they have filed given a notice for my eviction. So my possession is admitted.
Where is
And
that?
They say they have not put the lock. I have put the lock. So my lord, there is no denial, my lord, that I cannot, my lord, get access. But they say that
that they have filed a suit for eviction.
they have not filed. They have given the notice for eviction. my lord.
Notice.
They have given notice for eviction.
Have you given a notice?
Now, Lordship, kindly come. My written
When have you given a notice?
Notice
When
has
have
been
you
given
given a
on, my lord, 11th of July 2025.
notice I have.
So they were
11th July.
your tenant.
Yes.
So
They surrendered their Lordship.
show me the document that they have surrendered.
Kindly come. This my written statement, page 28, paragraph 16.
Page 28, paragraph 16.
16.
Yes. 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 Show me that you have they have handed over possession. Where is that statement?
So they are unable to run the business in the shop.
Mr.
They have
Mr.
handed over the keys.
Sir, show me that they have handed over the keys. When?
Lord, they have given a notice, my lord.
Handed over the
Page 38, I have stated.
request. Show me on which date that they have handed over keys to you. But it's taking law into your own hands.
Lordship, kindly come paragraph 11.
Yes. Give me the date when you have taken.
After printing the rent receipt, defendant will take area such and such along with the other.
Please give me the date.
Premises.
Please give me the date when they have handed over possession, and please show the document in
24th
support thereof.
April 2025. Paragraph 11, Lordship.
11
Yes.
last 4 lines, kindly see, my lord, page 27. They have admitted I am in possession. Last 4 lines. The shop
Right.
room is
Or
closed.
taking over
From
and
long under lock and key. Defendant did not file the suit for eviction. Plaintiffs are assuring that they will vacate. And defendant did never try to forcibly
When
evict the plaintiff. So there is no question of the plaintiff being evicted without due process of law. This is the admission in the written statement.
when have you
Lordship, it appears from
served the eviction notice? Show me that notice.
11 July 25.
8th of August 2025.
Yes.
So as on that date, you are in they were in possession. Admittedly, because you have served the notice for eviction.
The shop room was initially locked and key.
Yes.
Lordship, both the parties have put the lock. The petitioner and the opposite parties. Now, Lordship,
Contrary to his pleading, my lord, he has said we have not put the lock.
Show me that was your case. Both the parties have put the padlock.
Lordship, kindly come.
Then if both the parties have put the padlock, so they were in possession. Admittedly, if that is your case, because they were tenant, So if they have put in, you are accepting that they have also jointly. He is not accepting that jointly.
Tenant lots
So-
are accepting, but he has surrendered his right.
Show me
Lots
a
of kindly,
document.
kindly come paragraph 11.
Yes, yes.
The statement in para 3 is not at all true. It is true. It is not true that plaintiffs are presently conducting the business in the suit shop room, or they requested the defendant to receive the rent from Boisak 1429 BS, or the defendant refused to take rent as an of the rents received such and such, such and such. After printing the rent receipt, defendant will take all arrears and on such and such along with such and such, such and such, such and such. Now, Lordship, the kindly come the 2 lines after, or the defendant threatened such and such, such and
Sir,
such.
do you have any document with regard to the surrender?
Well, it is not their case. Page 40 is the objection. Kindly see, my lord, paragraph 5, 6, and 7. He has admitted that we are in possession.
Caveat, Lordship, yesterday I received this notice. I have to check the whether that there is document. Obviously, should be there is a document.
There cannot be. The pleading is that they have filed the given the notice of eviction. Kindly come to page 40. The written objection.
This there's an injunction order. Lordship, kindly come. The order of the impugn order. So this is alternative remedy.
Mr. Banerjee, there is,
My lord.
your lock is also there.
My lock is there, but they are not allowing us to enter.
They have put a
They have
padlock.
put another lock over my lock.
Yes.
What
So,
is
Come to page 41, paragraph 9.
I'm keeping it just after the vacation. So none of the parties will open this padlock. Ashwin.
Only paragraph 9, page 41. Kindly see once, my lord.
Yes,
there are
five-
Paragraph 9. He has said I have not put. Kindly see, my lord, para 9.
the
page
last
41.
paragraph of the impugn order of the first page?
No, their admission kindly sees, my lord. Statements within para 1 and 2 of the petition is a matter of record. Defendant can only say that the suit premises is under lock and key from long, but he cannot say that the plaintiff put 4 locks. It is false that the defendant has put a lock in the suit premises, as the defendant did not put any lock there.
Lordship, that document, Lordship, I will.
Where is the case made out? Please show me from the objection to 151.
My lord, contrary case, he has said they have not put the lock. Page 9, paragraph 9, page 41.
Page 41.
Page 41, para 9. They have said we have not put it. You have put it. Kindly see, para 9, page 41. Clearly admitted everything.
Can only say whether the suit property, the defendant can only say that the suit property is under the lock and key from long, but he cannot say whether the plaintiffs have put or 5 locks. It is false that the
Then,
yes, yes.
has put a lock.
Put
As
any
such, they
padlock.
did not put a lock.
I'm directing the police to open that padlock.
Lordship,
I'm directing the police to open that padlock. Or you will open your padlock.
Lordship, let me take instruction whether there is an
This is the last day, my lord.
right, whether there is any
He's
letter.
admitted everything, my lord.
Show me from the your statement. You cannot improve upon that. Show me from your statement that you have made out that case. That has to be reflected in your pleadings.
And para 5 also. It is the plaintiff who has put the lock of the objection, para 5.
So you have not put any padlock. That's your specific case.
Also, kindly come to the finding of the
No. Whatever finding I will come. But your case is, please, your case is that you have not put any padlock. So I'm directing that lock to be open.
written statement. I have specific.
Sorry, you are not. You have
Paragraph
not
11.
put the padlock. So you are not agreed if that padlock is broken.
Lordship, the case is they have
You put any padlock.
surrendered their. Yes, subsequently, Lordship, the
Show me your case in the pleadings that you have put the padlock. If you have put the padlock and I find that they are in possession, then proceedings for contempt will be started against you. In deliberate violation of an order of
Lordship,
injunction.
this is a proceeding under section 406, 106 of the TP Act. Notice is enough.
Oh, you don't have to file a suit and you can put a padlock. Is that the law?
The Lordship, this is.
Is that the law?
So where is the defense? Lordship, this notice is enough because he has surrendered his right.
Oh, no, you need not file any suit for eviction.
Obviously, suit for eviction.
Why? What for? If the notice is enough, you have got the possession. Why will you file a suit? Have you till now filed a suit?
Lordship, I have to take instruction. So in the meantime, Lordship, nobody will open the padlock.
Why? You have not put any
They are
padlock.
preventing us violating the court's order.
You have put the padlock, please take instructions and say, if you have put the padlock, I will record that. And if I find that was in violation of an order of injunction, proceedings will be initiated against you. And if you say you have not put in the padlock, I will direct removal of the padlock.
Let me take
Please
instructions.
come at 12. Take instructions, come at 12.
Lordship, 1 p.m.
Don't try to play with the orders of the court.
Let
Please
the
take instructions whether you have put the padlock, yes or no. I will record that. And if I find that that is in violation of an order of injunction, your client has to face the
Lordship,
consequences.
let the 1 p.m. Lordship.
That much I can ensure. No, 12. Yes. Yes, yes. এটা 12টার সময় রাখবেন। Yes, sir. Please let me call proceed serially. Yes, please let me proceed serially. Yes.
Well, I am for the petition. Before going to this impugned order, kindly hear me 2 minutes time, my lord. I am for the defendant, my lord, petitioner. The plaintiff filed the suit for declaration of share on the ground that the total suit property 101 decimal, 15
This is
decimal.
the impugned order.
The impugned order, last page. I filed an application under order 39 rule 4 for variation of the interim order passed in that connected suit on the ground that my
What happened to that order 39 rule 4?
order 13 rejected, order 13 rule 7 rejected.
No, but what are you challenging?
That's why my
Which order you are challenging?
order 39 rule 7,
Order 39 rule 7, not order 39 rule 4.
that was also challenged.
How can you challenge in
That
a
is
civil
applicable.
division
Right?
application?
It is applicable. Now, what happened to us? So kindly, I filed an application under order 39 rule 4 on the ground. My kacha house with tile shed is in the suit property due to ampan and erosion of
Damaged.
damage. I made.
You want to repair it?
I want to repair this kacha house.
Show me your application for local inspection.
Kindly-
Have you filed any application for repairing?
No, I filed an application order 13 rule 7. You kindly make an inspection whether this.
Mr. Dotto, the initial thing, if you want to repairing, that's the initial application. You can file order 39 rule 7 in aid of that. So you will collect the evidence, then you
No,
file.
order 13 rule 7. Kindly see my application.
Show me.
Kindly see my application. Page 56.
56, yes. By the order impugned, the application
participants.
building on the ultimate hearing of the suit. Let the suit proceed. Repairing I will consider.
24, Lord, I am for the petitioner, Lord.
Yes, Mr. Bongu.
Lord, in this matter, Lord, I am not challenging any order of the London judge.
You are challenging the.
I am not challenging any order of.
So what do you want? Expeditious hearing?
Yes, Lord.
Of what?
Lord, what is the reasons, Lord?
Of the suit. What is the stage of the suit?
All written statement are completed.
For injunction in hearing.
You know, already completed, Lord.
Injunction concluded. Now the other side has appeared. Defendants have appeared.
Before the lower court, Lord.
Yes, in the lower court.
But defendant, but I am the defendant. Lord.
Oh, you are the defendant.
My
This application under Article 227. You are for the caveator. Who is for the petitioner?
Mr. Roy, Mr. Parthupratim Roy is leading.
Passover. Yes, after the vacation. Yes, next.
I am doing.
Why?
Right, he's coming. He's coming. He told me I'm coming. Right, kindly grant me
It's
2
very urgent.
Yes, my lord. The 2101 filed.
2101. Don't take risk before the vacation. After the vacation. Go to 21.
The problem is that perhaps, my lord, as far as I am
Yes.
concerned, at the civil revision perhaps not like. Because, my lord, the
You want to withdraw that? Order 21 was disposed of.
Thereafter, miss appeal was rejected. Thereafter, revision. But second miscellaneous appeal will come. That is why.
Tell me that.
Yes, that is why, my lord, I have.
This application under Article 2, the learned advocate.
I am for the petition, my lord.
Yes. Very urgent.
Yes.
Not very urgent.
Yes. Suit for partition, my lord.
Yes,
Injunction order. I am the petitioner, plaintiff before the trial court, my lord. Suit for partition.
What do you want? What is the order under challenge?
My lord, injunction order was passed. My lord, they have violated the injunction order. Initially I filed an application under 151 for implementation through police. That was allowed. But thereafter, the police did not take any steps, my lord. I filed another application under 151. That has been rejected, my lord. On the ground that there is already a direction upon the police. Now, my lord, kindly, my lord. If my lord kindly comes to the, my lord, injunction order, my lord, that is at page 20, sorry, page 21. My lord, when I brought the suit property, my lord, that was a vacant land. Thereafter, they started construction, my lord. Construction is going on. My lord, if the nature of the suit, my lord, got changed, my lord, then I will suffer, my lord, a lot.
There is already an order of injunction.
My lord,
There is already an order directing the police to take steps.
Yes, my lord, but
So
police,
why another order is necessary?
Police, no, my lord, kindly comes, my lord.
Where is the impugned order?
Yes, my lord. My lord, my second 151 application is for the police to comply with the previous order, not. Yes, my lord, kindly comes to the application for once.
Come after the vacation.
My lord.
Not today, next.
My lord, kindly consider.
I am on the caveator, my lord. I have not been served.
This sub not today. Next.
My lord, kindly, my lord, one humble submission, my lord.
Yes.
If my lord kindly directs the police to keep a vigil, my lord.
Yes.
Otherwise, my lord, if the construction has been completed, my lord, already a floor has been completed, my lord.
Nothing will happen. Let them complete the floor. What is the suit for partition suit?
Yes, my lord. My lord, I will, my lord,
Nothing will happen.
thereafter they will be protected with this order of, my lord, where the construction cannot.
Nothing will happen. Partition suit. Nothing will happen. You will get a share in that. Yes,
My lord,
next.
Hello.
Yes, Mr. Senior appearing.
Yes, I am on the 28th. Lordship, this is the expeditious hearing, suit for 2008, declaration and injunction. Lordship, kindly direct the court to expedite the suit. 2008 suit, declaration and injunction.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned civil judge, Junior Division, Kakdeep, District 24, Paguna South, to dispose of title suit number 83 of 2008 expeditiously. In view of the order sought and proposed to be passed to the court of the light of the submissions made by the learned advocate for petitions, CO number such and such stands disposed of by requesting the learned civil judge, Junior Division, Kakdeep, District 24, Paguna South, to make an endeavor to dispose of title suit number 83 of 2008 as expeditiously as possible, but preferably within a period of 12 months from the next date fixed without granting any unnecessary adjournments to either of the parties. Yes, call the next matter.
Get full.
My lord, it is an application for expeditious disposal, my lord. The petitioner plaintiff, my lord, got a decree for the eviction suit, my lord, for directing the opposite parties to deliver the khas possession within 45 days, my lord. Opposite party, my lord, thereafter preferred, my lord, title
Under
appeal.
Article 227 of the Constitution.
This is my application. Defendant is the petitioner before your lordship.
Very
That-
urgent, Mr. Bhattacharya.
No, not so.
Yes, what is this? So I'm making it after the vacation, not today, next.
Madam, may I submit only on 24th, my opening, my lord. I will be absent because my elder brother, next Monday, my 27th, my lord.
Let it appear, thereafter you can pay. Yes, next.
I'm for the caveat. I've still not been served with any copy of that.
Not today, next.
32, I am for the petitioner, my lord. Proceeding under order 9 rule 13, stay application has been allowed without considering the, my lord, section 5 application. There is a substantial delay for a period of 10 months, my lord. Without considering that, my lord, the impugned order has been passed. And my lord, occupational charges has been granted for the succeeding month, not for the, my lord, arrear. For the succeeding month, the occupational charges has been granted.
No, hearing of the miscellaneous case has been directed.
Yes, without considering the, my lord, section 5 application, the stay
Section 5 has not been allowed.
not been allowed, not been heard of, my lord.
And stay has been passed.
Yes, my lord. For a occupational charges of rupees 5,000 for 3 rooms in an area around Beleghata for the succeeding month, and that too for the succeeding month.
The learned advocate appearing for the petitioner submits that
My lord, instead of contested, my lord, kindly.
many legal issues are
33 malad is an application for
yes, yes.
33 malad application for expeditious disposal of my execution case as well as police help application. Only suit was instituted in the year of 2000.
Execution case as well as
Police help application is
21 to
pending.
97.
Yes, malad.
208, which
Along with 208. Both is pending, malad. What has happened, my lord, 2005 suit, degreed in the year of 2018, appeal dismissed 2019.
Miscellaneous case is order 21 rule 97.
Yes. That is the order to
This
I'm
application under article 220.
as well as execution case, my lord.
Wish to appear on behalf of the defendant in a proceeding and
Extension.
for dissolution of my evidence has been closed, my lord.
Evidence closed.
Yes, my lord. Kindly seize the
Why? Who are you?
I'm a husband. Husband.
Defendant or plaintiff?
Defendant.
What have you done? Why it was closed?
Because my
You
lord,
have taken how many adjournments?
only one adjournment.
Only one.
My lord, kindly seize the record.
Record does not say so.
The previous occasion, my lord, because I have been suffering from my lord, paralysis disease after my cardiac arrest, my lord. 84, my lord, kindly seize is a disability certificate.
What happened on 9th of October is the date fixed.
Yes.
9th of October.
Yes. In the
Courts are open.
family court.
By the
Hi. 35 is my application, Your Lordship, for an expeditious hearing of an execution case in connection with a consumer case, Your Lordship. The matter was decreed. Thereafter, they had preferred an appeal before the National Commission that they have lost the appeal, against which they have filed a writ petition before this Honorable Court. That writ petition had been dismissed for default, but thereafter, even though that has been dismissed for default.
what is IA 105 of 2025?
That is an interlocutory application for attachment, Your Lordship.
So I'm directing that application to be disposed of. The this application under article.
Husband, my lord, filed an application under section 9, my lord, for restitution of conjugal rights. Subsequently, after paper publication, my lord, the matter was placed for ex parte hearing, my lord. My lord, after that
the vacation.
my
Yes,
lord, the liberty was given, my lord, on the one hand, my lord, the so-called petition.
Let me consider. Yes, pass over next. Pass over next. Pass over. Pass over.
39, my lord, I am for the petitioner, led by Mr. Tanmay Mukherjee, praying for after
Not today. Yes, yes. Next. Not today.
40.
Lordship, I am for the petition.
Yes. Very urgent.
Lordship, it is urgent because I'm coming from an order of the learned CGIT, wherein the next date has been fixed as November 6th. Now, we have been directed to comply with the impugned order, and the compliance is of 26th, 28th September.
28th of
September.
Yes.
So, Lordship, it's a very short matter. Kindly take up the impugned order.
Yes.
Page
Who is
143.
appealing for the other side?
None.
You're appealing for the other side?
No, there is no caveat.
Yes.
Now the impugned order states that the appellant.
The order under challenge. 28th of
28th of August.
Yes.
Page 143. Now, the appellant, a contractor firm, is covered under EPF and MP and PF code. So and so. Now, Lordship, we are.
Give me a minute. Please give me a minute.
Yes. I'm prepared. We have been termed as a contractor firm in this impugned order. Now our case before the appellate court was that we are not a contractor.
So those are on merits. Have you deposited the pre-deposit?
What I am on is this
Please
order.
deposit the pre-deposit. Otherwise, appeal cannot be entertained.
Kindly give me 5 seconds.
So those are on merits.
We are not a contractor firm.
Maybe that will be
There
considered.
is a different entity. We have been confused as the opposite party number 2. Lordship, kindly comes to page 61. It's evident.
So no order has been passed against you.
No.
For dues.
This order has been
for dues, recovery of dues.
The learned CGIT has termed us as they have given the wrong code which belongs to opposite party number 2. Belongs to opposite party number 2. We have been.
So those are on merits. Have you deposited the pre-deposit? Otherwise, appeal cannot be entertained. Why have you filed an appeal?
Lordship, we have been confused. I am only seeking for a remand so that
vacation, please.
Lordship, I am only seeking a remand so that we can get it reheard.
What reheard?
On the waiver application.
No, that other side's right has accrued. You serve that will be considered.
We are not saying that I am not willing to pay, but there is a wrong recording that this is our.
If there is a wrong recording, you go there, file a review application. All right. The learned advocate appealing for
Madam, I'm appearing on behalf of the petitioner.
Yes.
I'm led by Mr. Mohanak Bose.
Yes. Yes, is it very urgent?
Yes, my lord.
What is the
For
urgency?
expeditious disposal, my lord.
Urgent.
Yes,
And
my
Mr.
lord.
Mohinak Bose is appearing after
Yes,
the
my
vacation
lord.
next.
My lord, kindly, my lord. My lord, hear me, my lord.
Oh, yes.
My lord, kindly hear me. You have given, my lord, similar kind of orders have already been passed, my lord.
Mr. Mohinak Bose, you are appearing in an expeditious hearing matter. Any last the vacation, after the vacation?
No, my lord, only may I just say one thing, my lord.
Yes.
Just one word. My lord,
Yes.
there's a public property under the Public Premises Act which belongs to, my lord. My lord, there is a stay. The suit which is not maintainable, my lord, there's been almost, my lord, 7 years in a miscellaneous appeal from refusal of an ad interim order. A trespasser is enjoying a stay for 7 years. Just give that.
After the vacation, reopening, I am making it only not
My
today.
lord, the only difficulty, I'll tell you, lordship, my lord, more than almost 11 crores by way of occupational charges is due. This is the only situation. 7 years have gone by. Well, an ex-party ad interim order has been enjoyed by a trespasser. Well, this is the only difficulty. Nothing apart from that. Because
Yes. What is the expeditious injunction application to be heard?
yeah, which is pending in a miscellaneous appeal.
All right. This application under Article 227 of the Constitution of India is that the instance of the Shama Prasad Mukherjee, Calcutta, praying for a direction upon the Learned Additional District Judge first to dispose of the injunction filed this appeal number 106 of 2017 expeditiously. Mr. Post Learned Senior Advocate appealing for the petitioner submits that the injunction is otherwise ready for hearing. In the light of in view of the order sought and proposed to be passed, next, in the light of the submissions made by the learned by requesting the learned additional district judge, court, third court, and order to make an endeavor to dispose of injunction application filed in miscellaneous appeal number 106 of 2017 as expeditiously as possible, but preferably within a period of
My lord, SN Bandi, my lord, SD Bandi, and your lordship judgment, 30 days.
within a period of 4 working weeks from the next date fixed, without granting adjustments to.
Deeply obliged.
Next.
Is appearing for short.
Passover. Yes, next.
Millet, my application, Millet, order 7, rule 11 dismissed. Millet, suit for specific performance of an unregistered agreement for
vacation.
No. Millet, next date is immediately on the reopening.
On the reopening, vacation
on the
bank,
reopening.
first vacation
No.
bank.
Millet,
Yes, first vacation bank. First vacation bank.
Millet, 5 seconds. 5 seconds. More than that, my lord will shut me out. Suit for specific performance of an unregistered agreement for sale of 86. Suit filed in 2017. Interim order rejected on the point that the suit is barred by limitation. Now, Millet,
Rightly so.
Millet, on that, Millet, we filed order 7, rule 11.
Yes.
Very well. Millet, we are for the defendants. I bow down, Millet, rightly so.
Yes.
Now, Millet, order 7, rule 11 dismissed on the ground that Millet, it's a tribal issue. Now, Millet, suit, Millet, the learned court has also not, Millet, considered section 49 of the Registration Act that Millet, the unregistered document which is mandatorily to be registered can only be relied as a collateral document. Now, Millet, this is the main document, the main reliefs of title as a title suit. Now, Millet, I'm only seeking Millet stay of the proceedings. Millet, the interim order, Millet, the order.
Do you want to move it this side or that side?
Millet, this side.
Last day, I'm asking you.
Stay of the process because on the reopening date, the matter is there.
Specific relief factor in. Registration Act. দুটো দিন তো
Millet, Supreme Court judgment, I'm carrying Millet on section
Yes.
49.
Unregistered agreement, specific performance is not maintainable. Do you have an authority on that?
I'm saying Millet, it's a barred by limitation. 86 to 86 document.
No, you have said unregistered agreement, specific performance of contract is not maintainable soon.
No, I'm relying
Because
on section.
that's the main document. It's not can be used for collateral purpose, not for
used for collateral purpose.
Dean.
I'm only saying this is the main document.
Yes.
The suit is only on
It
that.
has to be a registered instrument in view of section 17 of the Registration Act. That's your submission.
First submission is on Millet limitation. Kindly see the document once. Kindly see
Yes.
the document once. At page Millet 40,
Yes.
42.
Yes.
At page 42. Kindly see the date. At page 42, kindly see the first line.
Please show me the plaint first.
Page 22.
22.
Yes.
Yes. Where is the pleading with regard to refusal? Show me that.
28.
Yes.
The original parties all have died.
Yes, yes. Please show me the date of refusal as pleaded in the plaint.
28, 29. Now,
Paragraph
kindly come-
28.
Page 28.
Page 28, paragraph. The Pachana Specific Factor Registration Act. Yes.
Paragraph 15.
15.
This Hillol Kanti Gu has expired long back in 90. Probate has been granted
Yes.
in my favor by this court in 1994. 86 document filed in 2017. Now, Milad, kindly see the interim order which was Milad refused on the ground that this is barred by limitation. Expressly barred by limitation, page 103. At page 105, specific observation of the court. Then same court. I filed Milad on that observation. I filed order 7 Rule 11. Kindly see Milad, page 105.
Wait a minute. Show me your application under order 7 Rule 11.
Yes. Milad, my order 7 Rule 11 is at page 51.
51.
51. And 81, Milad, a supplementary affidavit. Milad, main application is at page 51. And also kindly consider page 103 and 105. That observation has been upheld by the district judge.
Yes, what are the grounds in order 7 Rule 11? Please.
Limitation.
Yes, show me where.
Milad, kindly see.
Except limitation.
Milad, except limitation.
Limitation, which paragraph you have said?
Milad, supplementary application. Milad, supplementary petition. Milad.
Oh, not the main.
Of the yes. Kindly text Milad, page 81.
Yes.
Kindly text page 82. From bottom, Milad, middle. Prima facie barred by limitation. There is no explanation.
Yes.
Kindly see.
Page.
82. 82. Kindly see. My will find 30 years were written in figure. Bottom, Milad, Machkane to pore.
Page 82. Yes.
Yes. Kindly see. It's underlined, Milad, photocopy. Law of limitation. And there is no explanation with regard to the huge delay of filing 80 years. 30 years
Yes.
on the date of filing of the passing of the order. Consequently, held by the learned, there is no prima facie case. And this order I have annexed at page 103. Part of the supplementary. When Milad, the same court held, refused the interim order. Kindly see 105. Kindly see 105, last ordering portion in 2021. Kindly see last paragraph, 105.
Yes.
In the injunction petition, there is no explanation as regards the cause of delay caused in filing the suit after 30 years. The prayer for the plaintiff is at excessive time bar and barred by limitation. This they challenge in appeal. Appeal, Milad, this order has been appealed. Then, Milad, I filed on the same ground order 7 Rule 11. Same court.
Show me your show me the plaint that it has claimed part performance 53A.
Yes. Kindly see, Milad, the prayers.
Yes.
Of the plaintiff at page 37.
Yes.
37 it starts. Here ask for possession.
By that agreement, part performance, by that agreement, possession was given.
No, I am there. Now he said, I was removing me. he will be there.
So that is specific performance pursuant to the agreement. So, but you have taken the plea of 53A.
Yes.
The learned trial judge has
They-
said 53A. How does 53A
No,
come in?
That's their allegation I have stated.
Yes.
That's their allegation.
Yes.
That's their allegation.
Yes. This is an agreement of
Sale.
which date?
1986.
So prior to
Second-
the amendment of the Registration
Second,
Act.
yes, 2nd February
Prior to
1986.
the amendment
Yes,
of the
yes.
Registration Act. So part performance also does not require registration.
2nd February 1986.
Yes.
Like 1994 probate granted of the entire property to me, to my father. By this court.
Yes, what is your answer to proviso to section 49 of the Registration Act?
Milad proviso. Yes, Milad, this is not a collateral document. This is his main document. Milad, on this title, she is asking for title. That she is the owner. She is asking for possession on this unregistered document. But I was Milad on that point under section 49.
Sir, please look at the proviso.
Yes, provided that an unregistered document
Yes.
affecting immovable property
Yes.
and required by this act or the transfer of property at 1882 to be registered may be received as evidence of a contract in a suit for specific performance of the specific relief act or as an evidence of any collateral transaction.
This is not collateral. This is in a specific performance of contract can be received as an evidence even if it is unregistered.
Supreme Court
That's the proviso.
Milad, Supreme Court in 2025, Justice
So
Loyman bench.
you are arguing against the law. That is why I asked you.
I am on
Please come after.
limitation. I am on limitation.
Yes. Limitation I will consider. Please.
It's on the reopening date, Milad.
I'm saying that I asked you that.
It's on the reopening date. The lower court.
What will happen, Mr. Klasgupta?
I need not, Milad, I have filed there is no caveat. I need not disclose it to them that I have come before a lordship.
Yes.
Well, then I have to
stay.
Milad, I am seeking for stay of this limited stay for 1 day, Milad, for the day before the court.
Asun, there's this application under Article 227 of the
Constitution. Anybody.
Yes.
Then Milad, kindly see Milad.
No, no, no.
Milad, may I see? Kindly show me. May I show Milad Justice Bakchi's judgment? Milad, may I?
Mr. Dasgupta, then I will decide it. Mr. Dasgupta, if you are ready, I will decide
Milad,
it.
kindly provide me only one line.
Yes, yes.
Only one. I am not.
Show
I
me
will
the
not show.
judgment.
I will not show. আমি চলে যাচ্ছি।
Show me
Milad,
the
only
judgment. Show me the judgment. I will consider
No, I
that.
go out. Milad, only Milad. Milad,
Yes, yes, call the next
Milad,
matter.
on the next day, I can see it. Can you put that one line?
No.
Can you put that one line, Milad?
No, not now. Yes.
Milad,
Next.
for a day, Milad. For a day, Milad.
If you want to cite that decision, you can cite that.
Not bother your
I
lordship.
will
I
pass the judgment on that.
For a day, Milad. For a kind
Nothing.
Milad. For a
Mr.
day.
Das-
For a day on the
Please
next
call the next
date only.
matter.
On the next date only, Milad. On the next date. Can you make
It is however made clear that pendency of this civil division application shall no, no.
Milad, then,
Yes, yes.
but can you remove that line, Milad?
Yes.
But can you remove that line? না না যাবো না না
Last line টা কেটে দেবো।
না, না।
Yes.
44,
Not today. Next.
45,
Yes.
There is a caveat, my lord.
Yes. Can you not wait till after the vacation? So urgent.
Please, my lord, police cost has been paid. Order 9 Rule 13 is pending. So in the meantime,
Or
if I
order
am
9 Rule
evicted,
13 with a section 5 application more than 2 years delay. So he has to get, he has to cross that hurdle first.
yes, but even if I am evicted, then what
Mr.
remains?
Dey, you are opposing Order 9 Rule 13. I am directing the Order 9 Rule 13 to be disposed of.
But in the meantime,
It is
there
section
should be a
5 to
stay.
it. It is section 5 to it.
Thought out at first.
And there
I'm
is a
directing
explanation to it.
I am directing the section 5 application to be heard of.
The order itself says that the
If that
section
is
5 and
pending
the
and
order 9
you
Rule 13.
execute that in the meantime, Mr. Dey, the entire proceedings will be
Yes.
frustrated.
I tell you, Lordship, what has happened. They appeared in the suit. They appear for 3 to 4 days.
Maybe you have a very good ground in Order 9 Rule 13. Let it be heard out.
Till that
Maybe
time,
rejected on the ground of delay.
Yes.
But don't execute that in the meantime.
But we are not executing. Your Lordship knows that during Puja time, what happens.
well, police cost has been
Let
paid.
it be disposed of on the very next day.
What is the next date, please? 15th of November.
For awaiting police
15th
report.
of-
Today is the date.
15th of
Before the
November.
travel court, awaiting police report. What will happen to me?
15th of November is the next day.
Infraction.
So please don't execute. I am directing this matter
Kindly
to be
stays it
disposed
for
of.
a time being till 15th of November. My order 9 Rule 13 is heard out. After that, I have nothing to say.
Yes. What do you want?
Let the ordinary Lutheran along with section 5 be disposed of on the very first day on 15/11.
That is the date.
Order 9. Are you conceding to section 5? If you say I can direct.
No, I'm not conceding. I'm not conceding.
Ashok, this application under Article 227 of the Constitution of
It's only there. Let it be, my lord, for the further.
application to be expeditious, my lord. My lord, was that the appeal may be heard of expeditiously.
Let the injunction application be.
Actually, I want to show one prayer to my lord, order
Madam,
date.
injunction application is pending.
My lord, order dated 56. It was fixed for appeal hearing only, my lord.
But injunction is pending. Unless the injunction is disposed of, how can the appeal be taken up? Yes, call the next matter.
Item number 51.
My lord, they are fixed, ma'am.
Item number 51.
Yes, yes.
46. My lord, there are fixed matters.
12.
46.
Yes, yes. Call the fixed matters.
46, lord.
My lord,
My lord, fixed matters may be called.
Yes, sir.
46 আর হবে না?
Lordship, I have
Yes.
taken instruction. So I stand corrected the fact that Lordship, the predecessor interest of the tenant, that is the petitioner, one, Lordship, the Angkornath Kormokar was the initial tenant.
Sir, have you put the padlock?
No.
My question. You have not put the padlock.
I have sent a letter to the petitioner. This letter has been suppressed.
Yes. What letter you have sent?
Letter.
What is this letter?
The letter, Lordship, kindly excuse me, there is a mark. Lordship, kindly second page. That by putting the padlock, the petitioner has, Lordship, kept the shop room in lock and key last 2 years without paying any rent. And also, I requested them to open the padlock and Lordship to take all these belongings. This is the letter. Letter has been suppressed. This fact. And another letter I have sent. Sent through WhatsApp, Lordship.
Yes. So, and what is the other letter?
Other letter also sent, Lordship, this is not.
So you are consciously relying on these letters.
Yes, yes.
All right.
Now, another letter was issued. Lordship, kindly read it from the mobile because it is not legible. I have got a print out, but not legible. From the mobile, it can.
What is the date of that letter?
April 2025.
Yes. Give me. Not be read. Yes, give me the mobile. What is the date of this letter?
The receipt is not legible, but it is 5th April.
This is the 5th of April, 2025. Yes. And when the ad interim order of injunction was passed?
7th May 25.
7th of May 2025. Yes. And what is your case that when did you, so you have not taken any possession?
No, this is a local.
So its possession is with Mr. Banerjee's client. All right. So I'm recording that fact. Possession is with him. So I'm directing the police to restrain you from creating any disturbance. This application under Article 227 of the Constitution of India is at the instance of, these are the admitted facts, admitted letters. You have issued a letter and here is the admission. You have admitted it's in his possession. This application under Article.
Lock and key, Lordship, that is a.
Yes, lock and key under his possession. Whether he will open or not, you have not taken any possession. This application under Article 227 of the Constitution of India is at the instance of Mr. Banerjee. Where is the order of injunction? Please show me.
Page 24, my lord.
So for the
So, and you have not put any padlock, but the learned trial judge has said one of the
prayer of 151, prayer is, under such circumstances, your honor, be pleased to pass an order directing the defendant to unlock the lock which he put by him upon the locks of the plaintiff.
yes.
Prayer
So,
cannot be allowed.
but the learned trial judge has recorded their allegation that there are 5 padlocks, 4 put by the plaintiff, 1 by you. So, I'm recording your submission that you have not put any padlock. I'm directing the police to break open that padlock.
Lordship, so for the prayer of the one application under section 115 is concerned, that to unlock the, because unlock there is no part, because this prayer cannot be allowed.
Which prayer?
This prayer, page 38.
38 years. What is the prayer?
Of the prayer of the 151.
Yes.
My 151.
Prayer.
Prayer of 151 application.
Directing the defendants. No, I will not direct you. I will direct the police to break open the padlock. You need not open because you have not put the padlock.
No,
I will clarify that.
Second part is there, my lord. Second part of the prayer is, my lord, on the police assisting me to open.
Yes. So I will direct the police to break open the padlock. I am recording your submission that you have not put any padlock. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 10, dated August 29, 2025, passed by the learned civil judge, Junior Division, 2nd Court at Chandannagar District, Hooghly, in title suit number 156 of 2025. So, by the order impugned, the application, by the order impugned, several applications were disposed of and no, 2 applications were disposed of.
Lordship, kindly,
one was for local inspection, one was for injunction, my lord.
All right. So several applications were disposed of,
letter of the petition.
and several applications were disposed of, and one of such application was under section 151 of the Code of Civil Procedure, filed by the petitioner, praying for a direction upon the defendants to unlock his lock, which was allegedly put by the defendant upon the lock of the plaintiffs in front of the shop room, and if the defendants do not unlock the same willfully, to direct the officer in charge, Horipal Police Station, to assist the plaintiff for unlocking the lock of the defendant by the plaintiff with the help of lock brokers. First up, the learned trial judge, by the order impugned, rejected the application under section 151 of the Code of Civil Procedure on the ground that if the order for breaking open the padlock is allowed, then it will tantamount to restoration of possession of the suit property, when the main prayer of the plaintiff is declaration of his tenancy right. So, Mr. Banerjee, learned advocate appearing for the petitioner, submits that in violation of the order of injunction, the defendants opposite parties herein have put a padlock over the lock of the plaintiff's opposite parties in front of shop room of the plaintiffs. Plaintiffs / petitioners. First up, he submits that the application under section 151 of the Code of Civil Procedure was filed for implementation of the ad interim order of injunction through police help. First up paragraph, the learned advocate appearing for the opposite party submits that the petitioner has kept the shop room under lock and key for more than
2 years.
For more than 2 years. First up, he further submits that the petitioner, that the opposite party issued repeated letters to the petitioner asking him to open the padlock of the shop room. Full stop. He further submits that the petitioner was also requested to it further submits that the petitioner has also removed all his articles from the shop room in the meantime.
Last several years, he did not pay any rent to the.
So he further submits that the petitioner also did not pay any rent to the opposite party for several years. First paragraph. The learned advocate appearing in course of argument had learned advocates for the respective parties and perused the materials on record. Tarpore, the petitioner filed a suit for declaration of his tenancy right and for permanent injunction restraining the defendants / opposite parties from disturbing the peaceful possession of the plaintiffs of petitioners in respect of the scheduled shop room, and also from damaging or removing the business articles of the petitioner from the scheduled premises, and from damaging or demolishing the scheduled shop room until possession from the petitioner is taken until possession is taken from the plaintiff with due course of law. First up, in connection with the said suit, the petitioner filed an application under Order 39 Rule 1 and 2 of the Code of Civil Procedure and prayed for an ad interim order of injunction. First up, the learned trial judge, by an order dated 7th of May 2025, passed an ad interim order of injunction restraining the defendants' opposite parties from disturbing the peaceful possession of the plaintiff petitioner in respect of the shop room in the as mentioned in the schedule of the injunction application. First up, alleging violation of the ad interim order of injunction, the petitioner filed an application under section 151 of the Code of Civil Procedure, praying for implementation of the ad interim order of injunction and for alleging na kore alleging that the defendants opposite parties herein have put a padlock on the front door of the shop room over 4 padlocks of the petitioner, the petitioner filed an application under section 151 of the Code of Civil Procedure, praying for a direction upon the defendants opposite parties to remove the padlock put by the defendants opposite parties, and if the same is not put by the defendants opposite parties, the same should be directed to be removed by the with the assistance of the police and the local lock.
Lock over a lock, not a padlock. Lock over the lock of the plaintiff.
Yes, as I've said, over 4 padlocks, he's locked. First up, such application was rejected. Such application under section 151 of the Code of Civil Procedure was rejected by the impugned order on the ground that the direction upon the police to break open the padlock would tantamount to restoration of possession in the suit. First up, 151, you have filed written objection, or you have filed written objection to the
Objection against the 151.
Where is that?
Kindly come.
Page 37. So 40, Miller, 40.
Page 40. Page 40, paragraph 9. 7 to 9.
The defendants opposite parties contested the application under section 151 of the Code of Civil Procedure by filing a written objection thereto. First up, in paragraph 9 of the said written objection, it was specifically stated that the defendants have not put any lock on the shop room. First up, where have you said that you have issued a eviction notice?
In the written statement, my lord.
Subsequent,
Uh,
the notice has
in
been
the
obtained.
said written objection, in paragraph 7 of the said written objection, it has been specifically stated that from the eviction notice, it is clear that after the death of the original tenant of the suit premises, the same is kept under lock and key, and the condition of the suit premises is being deteriorated day by day and deteriorated day by day. Thus, it appears after going through the averments made in the said written objection, this court finds that the defendants opposite parties have not disputed the possession of the petitioners in respect of the suit shop room. Full stop. The petitioner has the opposite party claims to have issued an eviction notice on the grounds as contemplated under section 6 of the West Bengal Premises Tenancy Act, and one of the grounds stated in the written objection is that after the death of the original tenant, the premises is being kept under lock and key. Full stop. Thus, there is no dispute as to the fact that the original tenant was in possession of the suit property, and upon his death, the suit property is under the control and possession of the present petitioners. First of whether the petitioners are tenants in respect of the suit property cannot be decided at this stage, but the possession, but it is not in dispute that the petitioners are in possession of the suit property. Full stop. Since there is no factual dispute with regard to the possession of the suit premises, and the learned trial judge has passed an order of ad interim order of injunction, this court is of the considered view that under such circumstances, the court ought to have exercised its inherent powers under section 151 of the Code of Civil Procedure to court should have step in under such circumstances and directed and passed an order directing implementation of the ad interim order of injunction through police help. Full stop. Since the petition, the paragraph, the petitioner alleges that over 4 padlocks of the petitioner, the defendant has put the 5th padlock. Full stop. However, the learned advocate appearing for the opposite party denies that the defendants opposite parties have put the 5th padlock on the main door of the shop room. Thus, in view thereof, this court is of the considered view. In view thereof, this court feels that the officer in charge of the Horipal.
I'm instructed this is Horipal Police.
Of Horipal Police Station shall render necessary assistance to the petitioner for breaking open the padlock which the opposite party does not to break open the padlock which was not the keys of which is not lying with the petitioner at present. Full stop. For all the reasons as aforesaid, this court is inclined to interfere with the order impugned. For all the full stop, CO number such stands allowed. The impugned order stands aside.
Let the suit
Grateful, my lord.
The suit be expedited.
After this order is dictated, the learned advocate appearing for the petitioner prays upon
opposite party is praying.
Party submits that a direction be passed upon the how you will gain over of the filer suits for eviction. Prays for a direction upon the learned trial judge to dispose of the suit expeditiously. First of all, in the light of the such submission is not disputed, such prayer is not disputed by Mr. Banerjee, learned advocate for the petitioner. First of all, in the light of the submissions made by the learned advocate for the petitioners, the opposite party, the learned civil judge, junior division, second court, Chandanagar district, who requested to make an endeavor to dispose of title suit number 156 of 2025 as expeditiously as possible without granting any unnecessary adjournments to either.
Much obliged.
Service has been filed. The affidavit of service has been filed.
Affidavit service taken on record. Affidavit service. Yes. Next. You wait. You missed your chance. What can be done?
12 p.m. item number 50.
Some matters are fixed at 12 noon.
Yes, yes.
Please wait. Let me see. Let me take up those matters.
This is a custody matter, my lord. Your lordship will hear it after vacation. I don't have any problem. Only the difficulties, my lord. During Puja days, I have only prayed for 2 days. Then I'll pick it my daughter, my lord, at 9 a.m. and I'll drop at 9 p.m. So this is the prayer.
What's the other side?
Your lordship, I am led by Mr. Joydeep.
Last occasion,
Mr. Kaur.
And your lordship, Orunima Lala is also online.
Yes, your lordship. I am for the petitioner, my lord, for the opposite party, my lord.
Madam,
with regards to your lordship, with regards, there is difficulty. There is genuine difficulty, your lordship. The daughter, she is 3 years old. She is diagnosed with something called Hirschsprung disease. She has undergone 2 major surgeries, my lord. And the disease is with regards to her, a part of her colon being devoid of nerve cells. My lord, Mr. Kaur is there in the matter. He's leading me, my lord.
Just after the vacation.
Only one thing, my lord. Only one thing. Very well. Very well, my lord. What I'm praying before lordship. In that case, my lord, in the medical matter, then I have to, my lord, take also instructions. But in that case,
she was present on both the occasions.
Mr. Kaur, since you are here, for some time, may not be for long hours. Can it, the son, father,
problem is that, Lord, she is permitted, Lord, visitation 2 hours, Lord, thrice a week. And
but special festive season, can you not extend it for some?
That is, Lord, I have stated in the affidavit that, Lord,
affidavit, I will look it after the vacation, Mr. Kaur. Some hours during any 2 days of the Durga Puja. Any one day.
I can vouch for this.
Yes.
Lord, had she been a normal child, I would have more than, Lord, agreed. Problem is, Lord, she needs, Lord, care and handling. And Lord, medications are there, and Lord, she is under, Lord, tremendous, Lord, restrictions. Even her food habits.
What is the present arrangement for visitation?
She is going to school every day, madam. That is not a
But if you argue like this, then it will be difficult. I am posting it after the vacation.
She is definitely going to school every day. Her grandmother.
What is the present arrangement for visitation?
Arrangement is thrice a week. The mother thrice a week.
Yes.
Mother comes, Lord, to visit her between 6 p.m. to 8 p.m.
At your residence?
Yes. At my residence. Because, Lord, traveling is a big issue for her.
Mr. Chattopadhyay, I allow you on these puja days to go to the residence and to...
there are several complaints, mails.
Then I will...
May I pray? May I pray? In that case,
if you are agreeable to go to the residence,
I am going, but I can show you from the record. They are not allowing me in a very. This is not a normal case. This is not a normal case. Mr. Kaur is appearing. This is not a normal case. That will be also quite clear. This is not a normal case. Now, only one thing. In the meantime, when will I be
able to go to the residence?
I am going to the residence. There is no problem. I'm not saying on what I am saying, Malak. In that case, Malak, I will be allowed with my child in the playground in that complex only, Malak, for 2 hours.
With a nanny, she can.
But nanny some personal moments is also required with my daughter.
Mr. Chattopadhyay, I do not know what is the difficulty. You spend your
in the playground, Malak, I will have some access to with my
in the presence of whom? Please.
One nanny, no special officer. Kindly, have praying before your lordship. Serious problems are going.
And this is, Lord, court. When the petition was admitted, had appointed a special officer because of the acrimonious relationship between the parties.
The core, the difficulty is the distance. I have also appointed one special officer, but
The problem is that it is very difficult to control her. She doesn't listen to anybody. And my lord, one day she had given a knife to the child for praying. And this is on affidavit. We have brought it on record.
I can also go about. These are all my learner senior friend.
I think it's better. Ashun.
One thing, let the nanny remain in the playground. Let me play. At least 2 hours. But this much, if I cannot pray by a mother.
Which day nanny will be present? Which day will be convenient?
Lord, between 30th and 3rd.
Between 30th and 3rd,
the father, Lord, is taking the child out for a holiday. So between these 2 days, today, up to
30th and 3rd, you are saying?
Yes.
So can it be on 29th?
Yes, yes. No. 28th to 3rd, she's not there. 29th visitation. Of course.
So 29th, you go to the residence of the father and spend some time
in the playground.
What will be convenient?
Mr.
20 evening then, Mala. No, there will be sunlight, the problem because child then they will say the sunlight is there, so it's better at 4 p.m.
4 p.m. evening.
4 p.m.
Yes.
Lord, I don't know.
4 to 6.
4 to 6.
4 to 6 is always there. 1 hour maximum more if your lordship extends it. I am only praying a very
6.
I don't have any problem.
Let it be 4 to 6 because there is a resting time for the child also. She has
what is the resting time?
I think she gets up by 4 o'clock. Let it be between 4 to 6.
My subject to correction by my learned senior friend, but the situation is totally contrary to the record. Totally contrary.
Let us not fight out the matter.
I want that. Asking for this much.
This matter was mentioned by Mr. Chattopadhyay, learned advocate for the petitioner, praying for a direction upon the father opposite party to allow the mother petitioner to meet and interact with the child for 2 days during the Durga Puja for the year 2025. Mr. Kaul, learned senior advocate, appears for the opposite party. First up, he submits that the father is taking the child out of town to spend the vacation on and from September 30,
30th.
September 30, 2025 till October
3rd October.
Till October 3, 2025. First up, on a query of the court, Mr. Kaul, learned senior advocate, appearing for the petitioner, upon taking instructions from his client, submits that if the mother is willing to come to the residence of the father on any day prior to 30th of September, the father is agreeable to allow the mother to spend some time with the mother. Full stop. Paragraph. In view thereof, you have filed any application? No.
Yes. Can do. Yes.
This prayer is
yes. No. But I have prayed for interim custody only, madam.
So I'm disposing of that.
No. I'll come with the affidavits, madam. Only one thing, madam. Lordship will kindly clarify. Can do, I have for interim custody, madam, for 2 days.
At an interim order code. Can 2 of 2025 application.
Madam, only one thing, madam. Lordship will kindly clarify, madam.
কি বলে শেষ
আমি নাকি
ক্যান টুতেই মানে of the submissions made by the learned advocates for the respective parties, the mother petitioner is permitted to visit the minor son, minor daughter at the residence of the father opposite party on September 29, 2025, and to spend time and interact with the child on and from 4 p.m. on that date till on and from 4 p.m. till 6 p.m.
7 p.m. madam. 3 to 6, your lordship said, madam, or 4
Alright,
to 7.
7 p.m. 4 p.m. to 7 p.m. on that date. Full stop. Mr. Kaur submits that the nanny of the girl child shall remain. Mr. Chattopadhyay submits that the petitioner mother be allowed to take
In the
the
playground.
child to the playground inside the complex where the child is residing.
Yes.
Full stop. Mr. Kaur agreed to such proposal subject to the nanny being present with the child at that point of
Much
time.
obliged.
Full stop. It is made clear that the nanny shall be permitted to remain present with the child during the time of visitation. Full stop. However, the parties shall keep in mind that this visitation should be a meaningful one and no obstruction should be created by the father opposite party.
One request, Lord, she should not offer any outside food to the child in course of interaction. I only request this because, Lord, she has heavy restrictions on her diet.
My lord, one day if she comes, my lord, very well. Well, I'll instruct to my.
This is
I'll instruct her. I'll instruct her. Definitely, I'll instruct her so that she doesn't.
Cooked food? No.
That problem is that the ice cream also can't be offered to her. There are so much of restrictions.
Sweets are also given by the grandmother.
After all, it's
Yes,
your
yes.
child. You know?
And my lord,
Stop. Is it necessary to mention with regard to the
No,
food?
I'm just requesting my
Yes.
learned friend
Well,
because I
and my
don't
lord,
want
one thing, my lord.
Can too.
It might happen, my lord.
After the vacation.
It might happen.
Fix a date to finish off this matter,
Yes,
my lord, because the main custody matter is
All
kept
right,
pending because of
I'm keeping it after the vacation. After that,
Well, it might happen. My lord, the special officer, Ovik Bose, who is assisting, may not be available on that date. So, my lord, in that case, my lord, let them, my lord, allow. We'll in the
special officer is
Yes, yes.
necessary.
Well, not necessary.
under the order of your lordships,
Because,
lord,
my lord-
the special officers are coming. But during the puja, if you, one day
No, no,
exception,
puja one.
I can.
Very
there
well.
is-
2 days. These for these 2
I
days.
think Mr. Kaur is there. There
My lordship will clarify. My lord, otherwise, serious problems are going.
Nothing will.
Very well.
Yes, yes. Call the next matter.
But your lordship had
Mr. Kaur, please ask
The
your
lordship
client
has-
so that
I can assure your lordships that, Lord, every cooperation will be there from the
Very
part of my client.
thank you.
But
Because
the
the
only thing is, my client doesn't get any cooperation from the other side. That is the main problem. Otherwise, Lord, there is no difficulty.
Well, I'll come. Very
yes, call the next
lordship had
matter.
also fixed my item 51 my lord.
57.
But item 51 my lord, your lordship.
Milord here. Milord.
Oh, 51, 52, 53.
Oh, 51. तो
Oh,
आगे.
wait, no, wait. 57. Yes, who is
Yes.
in 57?
Yes, Milord. I'm appearing.
I have mentioned one also my lord.
To be taken up.
My lord, in 57, my lord, I appears for the opposite party along with Mr. Molay Bhattacharya, who is leading me.
Very innocuous prayer. Milord, I think the matter can be closed, Milord, in a while. Milord, there is a provision. My lord has made the provision, Milord, for interim visitation at Joy Krishna Library once in a week. Milord, I am not complaining that, Milord, that is being intermittent and all. Milord, today is the closing day. I am not getting into that. Now, Milord, Puja is coming. So, Milord, I want, Milord, my child to be there with me for 2 days. But, Milord, I am told that was my prayer, Milord, when I mentioned the matter.
Take the
During
child
this
to your residence.
Yes. I have a flat, Milord, where my parents also do not stay. Milord, I am agreeable, Milord, to the proposal. If, Milord, my wife wants to come to me, stay with the child along with me, Milord, I am ready for that also. I am amenable to that proposal also. But, Milord, I am told that, Milord, possibly they are planning a tour during Puja. Milord, if that is so, then, Milord, I cannot have the child, Milord, during Puja. Milord, I do not also stand in the way of the family too. Milord, may I have the child, Milord, today? Milord, I will return her, Milord, tomorrow. And if mother also wants
When
to...
you are taking the child for the tour? 28.
28th is Sunday.
It's difficult, Mr. Banerjee, because
Sunday we will visit, my lord. Sunday we will visit.
Sunday you are getting. Sunday you are getting.
Milord, spend one night with the child. The last 4 years as a father.
Mr. Banerjee, it's difficult because if he agrees,
Her also stay, Milord, in the same premises.
Mr. Banerjee, don't take that risk.
Not Milord.
Don't take that risk considering these relations.
No.
Don't take that risk.
Milord, let me have my child for one night. Milord, I will return her, Milord, before she goes to sleep. Before she goes to.
Not go, she is very adamant.
Milord, Milord, I am not getting into this. Who has been
on 27th, bring the child to that.
That is regular.
No, Milord, may I have
28th or 27th?
Sunday, Milord.
Sunday.
Sunday as in
So
terms of your lordship's order, Milord.
Milord, that I know, that I have indicated to your lordship. Milord, may I have some more time, Milord, with my child, Milord, during puja, or Milord, on the onset of this puja. This is, Milord, my humble.
So what is the period on Sunday?
Sunday?
How many hours?
So, Milord, may I have her, Milord, also on Saturday? Milord, let me, Milord, spend some time with my child as a father.
Not making this complaint at this stage, Milord.
Milord, I have also not made any complaint. I am sure mother will not stand in the way of the bonding between the father and the child.
We are not against that, Milord, but
Yes, on the Kali Puja day, you allow him.
Yes.
Kali Puja day.
Sometimes.
That even, Milord, we have to take instruction.
Instruction.
Considering facts is this, Milord, child is last 4 years. Residing with the grandmother and grandfather, Milord. Milord, what the father did, Milord, last 4 years. Now, Milord,
see, this present arrangement from 12 to 5 at that library on the Kali Puja day also.
on the library.
And may I take the child tomorrow? Milord, may I take the child tomorrow? I'll return her, Milord, to the mother before she goes
He
to
agrees, Mr. Banerjee, otherwise.
But she will never agree. And Milord,
then
the child will suffer.
Mr. Banerjee, then I will hear it after the vacation.
So, Milord, kindly make a provision for Kali Puja. Milord will come.
Yes. Agreeable Kali Puja from
on Kali
12 to 5 at that library.
No, Milord, on Kali Puja, Milord, let this not happen in Joy Krishna library. Milord, may I take her, Milord, to any, Milord, ki ye baji bikri hoy? Milord, any, Milord, fireworks, Milord, exhibition come sale, Milord, those centers. May I buy something for her?
Single day.
Yes, he will take and return on the same day.
Milord, instead of Kali Puja, let it happen on Jagadhatri Puja, because Milord, I stay at Chandannagar, he stays at
Jagadhatri Puja, then I am keeping it after the vacation. Jagadhatri Puja is after the vacation. Keeping it after the vacation. So after the vacation.
No, Kali Puja. Let us have the Kali Puja first, Milord, then we'll have the Jagadhatri Puja.
So take in installments, Mr. Banerjee. Take in installments.
Child part is concerned, child will not go outside, Milord, without the father, Milord. That is the problem.
Mr. Banerjee, learned advocate, appearing for the petitioner, mentioned this matter upon notice to the learned advocate for the opposite party to allow the petitioner father to have
The girl child.
To spend some quality time with the daughter, with the minor daughter on the day of Kali Puja. First of, what is the date?
Kali Puja koto tarikh tatari bol. Milord, kindly keep it blank, Milord, I'll supply that. Kindly
Yes,
keep it 19th.
Mr. Banerjee submits that your residents are near.
Yes, very close. Milord, she stays at Uttarpada, I stay at Chandannagar.
So at what time we will take the child?
Milord, for 6 to 10 hours. Milord, any time that, Milord, I leave it to your lordship.
Will
not go, Milord. That
yes,
please.
Not cooperate. Then take
Milord,
it to
she is dying to come to me. She is
Mr.
dying to
Banerjee,
come to me.
please don't take that risk. So any place, any other place,
Nico Park. Nico Park, Milord. Let me take her to Nico Park.
Far away.
আরে বাবা একটা বাচ্চাকে নিয়ে নিকো পার্কে যেতে পারবো না ছুটির দিনে?
Then the mother has to accompany.
Yes, let her. Milord, I'm not, Milord.
Mother has to accompany.
Yes, আমার অসুবিধা নেই।
বাচ্চা নিকো পার্কে যাবে তাতে আপত্তি?
Day out.
হ্যাঁ, day out. নিকো পার্ক
Yes,
বন্ধ হয়েছে।
on that day, mother will also accompany.
Yes.
They will spend the day in Nico Park and
Yes,
return.
yes.
Yes, 11 to 5.
At Nico Park, 11 to 5.
Submits that the petitioner father be allowed to take the child along with the mother on the day of Kali Puja for spending the time there
at Nico Park or any other
at-
amusement park
at Nico Park
or any other
or
amusement বন্ধ থাকে
at Nico Park or any other place that may be mutually agreed by the respective parties on and from 11 a.m. till 5 p.m. on that date. Please give me the date. Mr. Bhattacharya, learned advocate representing the wife opposite party, does not oppose such prayer. Full stop. In view of in the light of the submissions made by the learned advocate for the petitioner, now for the respective parties, the father petitioner shall be allowed to take the child along with the mother on the Kali Puja day to spend some time with the child on and from 11 a.m. till 5 p.m. on that day, and shall
at the spot. Yes, very well. Very well. At 11. Yes.
mother will not accompany.
Mother will not accompany. Well, my doors are open for her.
So where so at spot she will also go to Nico Park. আচ্ছা তাহলে accompany না করে কি বললাম ওটা কেটে দিয়ে লিখুন Mr. Bhattacharya, learned advocate appealing for the opposite party submits that the mother is not agreeable to accompany the child, but the mother shall take the child to Nico Park on that date. We date the same date করে দেবেন at about 11 a.m. Full stop. The mother the father shall return the child to the mother on the same day at about 5 p.m. Full stop.
And Miller, this Sunday, now he is saying she will follow. Why follow? Let her be with me.
All right. The mother shall be also permitted to remain at the Nico Park at that point of time. Full stop. The parties are parties shall see that the visitation is a meaningful one. Full stop. The mother shall not create any obstruction during such visitation between the father and the child.
But one more Miller's indulgence.
Not more. You have got
may I complete my sentence?
Yes.
Millard, may I take the child on Sunday, Millard, for a pandal hopping during the scheduled time?
That Mr.
Yes. Millard, that day is Millard,
returnable after the vacation.
Instead of Joy Krishna Library, may I take her Millard for a pandal hopping?
This matter after the vacation.
Millard, Sunday is Millard the day.
No, not Sunday. You have I've given you that option. Now
Sunday Millard, there is a visitation.
Now you are saying no.
Sunday Millard, there is already a visitation at Joy Krishna Library.
That will be
Millard,
done.
may I take her for a pandal hopping?
Yes. If the mother is agreeable, you can take. Got that, Mr.
Millard, without my lord's intervention, Millard, this won't happen.
Yes. Call the next matter.
And the
I am for the petitioner, my lord.
Opposite party.
I am for the petitioner, my lord.
Very urgent. Not urgent.
Not very urgent.
Very urgent.
Not
What is
very
the urgency?
urgency, my lord. The plaintiff petitioner filed a partition suit, my lord.
What is the urgency that you are on?
Urgency is, my lord, in the
vacation. Since there is no urgency, list this matter immediately after the vacation. Yes, call the next matter.
Item number 60.
May I please, your lordship, my lord?
Not today. Next.
My lord, admittedly a tenant prior to the mortgage. Admitted position. The deed mentions that I am in possession of the property. The entire property is tenanted. I am the tenant. Since 2014, there is a dispute civil court list pending. Civil court protects my possession vis-a-vis the property in question. However, the bank, after obtaining a decree, has put the decree into execution to the learned recovery officer. The learned recovery officer passes an order whereby appoints a receiver to physically dispossess me. Now, my lord, I file an application before the learned recovery officer. The application was filed anticipating that there will be a date of hearing. Without fixing any date of hearing, the learned recovery officer passes an order and it dismisses my application.
Where is that order?
My lord, that is appearing, my lord, at page number
Order dated 27th of August.
27th of August, my lord. Now the immediate urgency is that I will maybe physically dispossessed by the receiver from the property in question without considering my application by the learned recovery officer, despite the fact that there is an interim protection granted by the civil court. My lord, the civil court order, my lord, may find at, my lord, at page number 60. Operative portion, my lord.
Order dated 27th of August. It's not a complete order, Mr. Mishra.
My lord, may kindly consider the last 2 pages of the application. The complete order is there, my lord. And this is also annexed at page number 60.
The last page has come first.
I'm so sorry, my lord.
Exercise in jurisdiction.
I'm seeking only this protection that, my lord, in the vacation, there are no courts. My lord, I may not be dispossessed. My lord will direct the recovery officer to hear the application substantially.
No, that has been dismissed.
Dismissed on the day of filing. And my lord, this order is uploaded on 7th of September.
If there is no merit, Mr. Mishra cannot be dismissed on that day.
After hearing me, my lord, I have judgments to support my cause. The primary
has been heard.
No, my lord, the day I file an application, he keeps it. Thereafter, doesn't fixes a date of hearing. Surprisingly, on 7th of September, I find that an order is uploaded and this is passed, whereby, my lord, the learned recovery officer sanctions the receiver to take further steps. He dismisses my application.
The grievance of the petitioner is that
Sure. My lord, I not waste your lordship's valuable time. It's really urgent.
Thank you, Mr. Banerjee.
I'm grateful. It's really urgent.
I thought that you will be praying for adjournment. Then you are saying urgent.
My lord, let me, in short, let me explain. Yesho Chandu.
Lordship, with the deepest respect to my learned senior counsel on the opposite side, I have a point of maintainability. Lordship will kindly.
What is the grave urgency, Mr. Banerjee?
Tell is the my electric connection has been disconnected. Disconnected, not by CSC. Let me explain in 5 minutes back. My client,
Mr. Banerjee, reconnection.
My lord,
when it was disconnected.
Kindly see the civil court reviews the order. Very unfortunate.
When it was disconnected.
11th August.
11th
I filed a suit. No. I filed a suit.
Yes.
Kindly see I filed a suit. The suit, and I also paid for injunction. The trial court says that these amount is due. I said very well. If the legal amount is not a CSC minor. The building where I was inducted as a license on 1st April 2025. So my lord, I was interested in licensing. I was already been member of the association. Entire thing is controlled.
Which order you are challenging?
My lord, this is the order dated
Not a member of the
19th September.
wrong submission.
কি বলো?
Association is wrong submission.
They claim, and during the course of hearing, they say, no, 2,50,000 is due. Where will you pay that?
Lordship, may I kindly?
If they pay the entire dues,
If they are not, that is not our entire dues, Lordship.
what is the entire due?
12 lakhs odd is the entire dues.
12 lakhs.
12 lakhs
from what?
is the entire due.
What for? First April I was inducted and I'll pay the development fee. I'm not nowhere collected. I'll tell you that.
Which order you are challenging?
My lord,
Which order you are challenging?
Lordship, they've been inducted in
19th September.
2008.
19th September is order 7 rule 11 rejected.
No, order 7. Page number, please. Certificate is there?
Yes, sir. Which application was rejected?
Yes.
151.
Yes.
What was the prayer in 151?
For any city? I'm doing business over there, my lord. I'll be in street. What is my fault? I don't understand. Now they're claiming to like 30,000 and in course of hearing, my lord, they came with that. I'm very ঠিক আছে টাকা নাও আমার বাঁচাও for the time we do not dispose of it. Can't keep it pending.
Lordship, may I kindly make a small my small bit of submission regarding the maintainability first? And then I come to the quantum and the powers and so on and so forth, Lordship. I have 10 minutes of submission for your Lordship regarding this, Lordship.
Mr. Banerjee, it was disconnected on 22nd of August.
Well, kindly appreciate.
Keeping it after the...
No.
If you want, I'm keeping it before the vacation.
No, kindly appreciate. Kindly appreciate.
If you are agreeable to pay the entire dues,
yes, to like that is the claim.
12 lakhs.
How? On what basis?
That I
maintenance. No, but I was inducted on 1st April. What is talking about?
On account of electricity maintenance, what is the dues on electricity?
Lordship, may I kindly now? Yes. Lordship, there is a civil suit. তারপরে আমি on that side, Lordship. I may be a junior member, but I will assist your Lordship.
No, I'm not saying
senior
No.
If he wants to raise a maintainability, let him take that point first.
So grateful, Lordship.
Yes.
Lordship, there is a civil suit being CS number 842. Lordship will kindly turns to page number 159 of the petition, Lordship.
Yes.
I'm not a party in that suit.
Yes.
Might not be a party, but there is a civil suit.
Mr. Chatterjee, you are a senior member of the bar. Please allow him to make Don't make those side comments.
No, it's all right.
The amount that they are paying today, they've already spent on legal. Be that as it may have.
159, yes, sir.
Lordship, 159 is an order dated 28 September 1989.
Yes.
Since suit number Ullakhani, this is 842 of 89, Lordship, in the Honorable High Court, pending as on date. It is running in Lordship's list before the learned single judge. Lordship, yes. This order, I'll tell you, there's a checkered history in this property. Lordship, the promoter, the developer, the owner, everyone.
I'm sorry to interrupt. Maintainable point, but the checkered history. Today is the last day. What is talking about?
My power, Lordship, will kindly turns to the powers that were granted at page 162. So this is a consent 2.
Yes.
In that part of that order only, Lordship.
Yes.
Starting at 159 at page 162. I am reading, Lordship, point number 10A, 11 and 12.
Yes.
The administrator will be at liberty to make ad hoc collections for maintenance, management of the building from occupiers of the Poddar Point. Lordship, the administrator was appointed for maintenance of the property. Why, Lordship? Because the property was going to ruckus, and the association had to file a suit asking for administrator to be appointed. Lordship, the learned single judge was pleased to grant me the power, grant the administrator the power to disconnect electricity if there are dues on account of maintenance and electricity charges. Lordship, thereafter kindly turns to when I got this power, the administrator was recused and I was made the administrator.
Show me that you can disconnect electricity even for default of or dues of maintenance.
May I kindly, two things I'll show you will be there.
Show me first. Come to
point number 11 on that page only, Lordship, 162.
Yes.
Administrator will be entitled
What is the amount due on account of electricity? Please tell me.
I'll tell you. I'll first show you the powers and then I come to account.
That. Paragraph 11 I have seen.
Paragraph 11 and 12, Lordship. The administrator will be further directed to take penal steps against the purchasers of the shop room
2,50,000.
fault of any payment as aforesaid.
Yes, yes.
By way
11
of
and 12.
disconnection of electricity and water supply.
Yes, what is the due on account of electricity? Please.
2,50,000.
Lordship, the due on account of electricity is 2,51,000 odd. The account of maintenance is around 8 lakh rupees.
Stop the maintenance. Stop everything. But
Lordship, may I kindly make one more submission?
Yes.
Lordship, there is a memorandum of association regulations of the association. Kindly turns to the regulation of the association. They are bound by those contractual terms. They are being the members of the association. They are bound by the regulations of the association. Since 2008, they are in possession, and since 2008, they have been paying. Only in the past 2-3 years, Lordship, they have come up in arms with the association. They are trying to lower the dignity and authority of the association by various means. There are 144 proceedings, 156 proceedings. Their sister concerns are encroaching properties, lots of other things. So this is not about. This is not about.
You take all steps. I'm not stopping you from taking all steps. You stop all the maintenance. I'm not
Stop all
stopping
the. Lordship, there are 100 units. Lordship, in the property, if
everything.
My monthly expenses are to the tunes of 10 lakh rupees to maintain that 11-story Park Street building, Lordship.
Yes, yes. So stop other things. But electricity you have disconnected. What is the due on account of electricity? Please show me that.
Lordship, they have attached a ledger that I had handed up in the learned trial court that will show the electricity dues.
Show me that. What is tell me what is the amount?
Page 351, volume 3.
Yes.
2,59,000. 2,59,000.
Maintenance.
And very rightly, my lord pointed out it was attention. Otherwise, development is
351.
Yes.
I'll pay that.
351 is 2,59,191.
Electricity, Lordship.
Yes.
Lordship will kindly now see the terms, the regulation one, when I am empowered to.
I will consider that. Please restore the electricity. Let them pay this. Get some amount. Otherwise, no use. You stop that. You will not get any amount.
Lordship, this is under my powers to do this by a learned single judge's order.
I'm keeping this. I'm not disposing of this. I'm keeping this matter. Ashun.
Lordship, this will be in the nature of modification of that order of his learned judge, Lordship. Learned single judge, this will be in the nature of modification of that order, Lordship.
Yes, yes. Application under Article 227 of the Constitution of India is at the instance of the Mr. Banerjee, who are you?
I am the actual plaintiff, occupier.
Lordship,
I
may
reflect on 1st April 2025.
Lordship, in the interest, may I kindly place one judgment, Lordship? This is a Telangana High Court judgment, Lordship, wherein a provision, so grateful, wherein a provision in their Apartment Ownership Act was challenged, where the association was empowered by that provision to disconnect electricity for maintenance dues. Exactly this point was raised, Lordship, where the learned High Court held that no, the fundamental rights are subject to reasonable restrictions and copy of maintenance.
This pending, I will decide that. I will again allow you to disconnect.
Yes.
I will again allow you to disconnect. I am keeping this pending. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 7 dated September 19, 2025, passed by the learned judge 5th bench Civil Court at Calcutta in title suit number 1903 of 2025. So by the order impugned, the
Here. So do not even from somewhere, I'm sure. My lord. So do not. Thing. RTG.
You did not get any opportunity to settle that.
My lord, one thing.
The one who settled has to take this responsibility.
Lordship, the affidavit is signed by someone who's calling himself the director. He's not a director. I have the MCA data. I mean, there are material defects in the draft.
Yes, call the next matter.
My lord, extrusion must be within 24 hours. My lord, if the through RTG, my lord, immediately money is received.
I have to get an
Within
electrician
24 hours.
Puja the electrician Pabo ki na hota hai.
From the payment made 24 hours.
Pulled on or off.
That I do not know what they have disconnected.
Okay, but jai tale.
I've said within. So that's the outer limit.
Within, outer. I'm get flat.
Can be done within.
But may I leave, my lord? May I get flat?
Thank you, Mr. Banerjee. Yes. Yes, yes. Cannot wait till after the vacation.
Before vacation, my lord. Before vacation, my lord. Before vacation, my lord.
Yes, what is the urgency? Please show me the urgency that it is to be taken up for before the vacation. What is the next date fixed? Expeditious hearing.
Next
What
date,
is
my
the
lord.
urgency?
12th December
Yes, which
2020.
application you want expeditious hearing? Transposition
14.
application.
Order 14, Rule 2, Sub Rule 2, my lord.
Transposition petition.
Order 14, Rule 2, my lord.
2019 file kori.
Suit was filed on my 2019 and application.
In this application under Article 227. ঠিক আছে শুধু যে মুভ করলো তার নাম ইয়েস আর কারুর নাম দেবেন না ইয়েস ইয়েস ওইগুলো থেকে 51
Yes, my lord, I beg to appeal for the petitioner, my lord.
Yes.
My lord, I had filed an application, my lord, for visitation right for 2 days during Puja, during the Durga Puja, and 3 days during Kali Puja, my lord. That
For
has
what?
for visitation right, my lord. Visitation right for pandal hopping, my lord. Now
What is the order impugned?
that was my visitation rights has been rejected on the ground, my lord, that I have delayed in filing written statement, and also, my lord, that the divorce suit may get prejudice, my lord. This is the ground. Can you cease, my lord, the impugned order, my lord? But I have asked, my lord, 2 days visitation right for Durga Puja, my lord, from September 28 to October 2025. And my lord, I have
What is
also
your application?
my application, my lord, is at page number 20. 1 minute. 20.
What is the age of the child?
25.
13 years.
13 years. 13 years, class 8. my lord. And can you see the reason why it was rejected?
Daughter?
No, my lord, son.
Son? Yes, Mr. Mitso, yes.
Before my lord, the issue is not that regular visitation application has not yet been disposed of. That is fixed on November, my lord. 3rd November. Now, my lord, it's not on the mother. The child is not willing. See
that
the
torture,
everybody takes.
see
the torture he is doing to his child.
That is
Regularly,
over there, my lord. We found, my lord.
Directed the father to come and approach. The father has
But
not.
kindly consider, my lord, that
Bit after the vacation.
my lord, kindly consider this. My lord, I am father, my lord. My lord, I want visitor, my lord.
No.
Kindly see whatever he has stated, where it is.
All right,
written, my lord.
that has to be considered.
It is not there, my lord. No objection is
All right.
has been
Please
taken, my lord.
after the vacation.
Kindly consider this, my lord. A visitation right of father, my lord.
Yes.
My lord, give me at least 3 hours.
Why have you not filed your written statement?
It is still had been filed, my lord.
When have you filed?
Within 4 months, my lord.
4 months.
My lord,
What is the time limit as per this?
my lord, first, my lord, we appear, my lord, and we filed this application, my lord, for visitation right. That was fixed on November, my lord. So that is not under my control, my lord. Thereafter, my lord, we filed this interim application, my
Yes,
lord.
Mr. Bhattacharya, can you not allow him to meet his daughter?
Father, my lord, has the right, my lord.
Yes, Mr. Vich.
Just show to you this photograph. The father is teaching this family. Your lordship will kindly see the photographs. It will speak for itself.
Photographs, my lord. How the photographs
Every
can do
time the
anything?
son was sent there, then how the father treated blood and your lordship. I got the school diary.
My lord, kindly consider this, my lord. This photograph is there.
This
kindly consider, my lord, in presence of a special officer, my lord. If
not now, it is to be hard.
Kindly consider, my lord, in
this
special of
application-
will for the special officer, my lord. Kindly consider, my lord. My grandmother is there, my lord, and my lord, during Puja, my lord, we want to give gift, my lord. And my lord, one birthday also, I get visitation right, and there is no allegation that anything has happened.
No. On the date of birthday, he went and made serious other for which
my lord, matter was mentioned. This
Those documents, means of affidavit, my lord.
the petitioner will be the opposite party will be at liberty to file an affidavit in opposition to this application.
And we'll also file reply to that, my lord. We'll also show.
Yes, call the next matter.
To my lord, in this matter, I am appealing for the petition. Same thing, my lord.
Custody. Well, where is the other side, Mr.
Yes.
Rai?
There. Yes.
I'm appearing for the opposite party.
My lord, can you turn to page 70? Court premises, this incident occurred. My lord, can you forgive the same? I am not also.
Page
70.
70. Yes.
This was the incident occurred. I filed an application.
No, you are resisting the custody.
Yes. Initially, you have given consent, my lord, visitation.
Visitation.
Yes.
It has happened. My lord was pleased to direct to take up this application for the purpose of consideration before granting any other application concerning. They filed an application for temporary visitation during the puja. But I put this question to
What
myself.
happened? That was allowed.
That was allowed for 5 hours in a room. I could have understand. Let the
Special officer has also been appointed, Sir Rai.
father will be 5 hours from 10 to 3, 11 to 3. If somebody in one room, I can understand. And there is an incident. That is why my lord, I am.
Special officer is there, Mr. Rai. Special officer has been appointed.
So incident was occurred.
But the Mr. Rai, special officer.
So that is why from the very beginning I said, keeping aside all those things, this is a subject of dispute. In a room, my lord, a child.
Where do you want?
There is a Korporator Park in Bardhaman.
Park.
My lord, may I submit this allegation that they are saying that the father has assaulted the child? In my submission is it is completely false. We have filed a criminal revision against that order that has been stayed yesterday by Honorable Justice Uday Kumar, finding prima facie that there is a discrepancy in the FIR made and the application made before the learned district judge. So the argument that the father assaulted the child does not stand. Injury is absolutely simple in nature and absolutely fabricated, my lord. Father enjoys only twice a month. Instead of twice a month, learned judge was pleased to give 4 days in a month during the puja vacation. It's not harsh at all. That too in the presence of a special officer, my lord.
Right.
That is why if your lordship
Is the impugned order, my lord. Then
my lord, I have to say, at the very beginning I have submitted that I don't want to urge.
The child in his chamber.
Mr. Rai,
My lord,
you
kindly
have been
cease
given
one observation
permission to
impugned
visit
order.
in the chamber of the special officer.
Whether the father can stay over there 5 hours in a room.
Seize the impugned order. My lord, kindly seize
In
the
absence of
observation
mother.
judge in the impugned order. My lord, kindly
I put
seize
this
the
on
impugned
myself.
order. My lord, kindly.
The father can stay.
Lord,
Any person can stay in a room.
my lord, on
But
being
Mr. Rai,
very beginning,
there are two things.
my lord, 2 lines. On being heard the minor personally in my chamber, I have gathered that severe mental torture are inflicting upon the minor by means of torture, pain, trouble, and anxiety. My lord, the child is in the custody of the mother.
And that also happened.
I get twice a week and I will torture my child.
Yes,
My
that
lord,
happened.
That will affect my custody in the long run. Absolutely false allegation. Lord, it simply cannot be allowed.
Don't go by the allegations.
My
Here, it was directed in one room from 10 a.m. to 3 p.m.
My lord,
Instead of a room, can you agree to a different place?
That is why I am very busy and say.
My lord, in
Can you agree, madam? I am asking you to please consider the welfare of the child also. In one room for 5 hours, please consider that. I am asking you any other place according to your choice also.
That is why for the very beginning submitted.
Child will be 5 hours confined in one room. That is why please suggest a better.
My lord, the petitioner is amenable to if the location is changed. My lord,
where please suggest. That is why I am asking you.
Submission would be not to alter my submission. My lord is not the mother should not be present.
Madam, I will
during the meeting,
come to that. Please suggest the alternative place.
My lord, I will just.
Korporator Park. There is a park, so the.
My lord, park for 5 hours. Child will be tired in the heat, and if it rains during pujas.
Any mall.
Lord, that's the child, 6-year-old child.
There is a say that the rooms and other things are there.
Hours in the shade.
Child will 5 hours can you consider? Now I am placing one at the 5 hours.
No, Mr. Rai, only one thing from 10 a.m. to 3 p.m. in a park.
The child.
So, my learned friend is suggesting that
no special officers this chamber nearby the residence there is anything, so I can do one thing. You can spend some time there, take it to the park.
This 5 hours
no 5 hours for some time in the room and for some time so any other nearby locality, because 5 hours in a park or something from 10 to 3 it will be also
child will be able to.
The child will want to go to the toilet.
Rai, I cannot make you understand. For 2 hours let it be in the room, then for
may I submit one
from
thing,
10 to 3 in the park. That is
why I'm saying two things, Your Lordship. Reduction of the tenure duration.
No, my
5 hours, my lord. It is visitation. The father,
my lord,
the child is ruling. From where the learned court winners came to the fighting that.
For the last 6 months, I was meeting my son on this false allegation. I'm starved.
What is the false allegation? It is not that it is declared by the court.
Mr. Rai, it's only for 4 days.
Do you want me to?
It's only for 4 days. So I will mention. I will record that. It will not create any special equity for that. But what other arrangement? Because park may be difficult from 10 to 3.
And my lord, consider the child will want to go to the toilet.
Then let me
rest for some time.
What my learned friend is submitting is something known to everybody. So in a room, whether there is something is done, it is possible for a person to stay. Yes, Justice Officer. I am praying before your lordship.
And both of you agree to a place.
I am agreeing, my lord.
Where?
As my lord suggested, little bit in the park and little bit in the special officer's residence. I have no objection to that.
Any nearby park to that residence, Mr. Rai, I think that's better.
Room was others amenities are there.
Where?
Kalpataru Park. This is a big park within the Bardhaman.
There's a room also. Then it's not a
We
problem.
do not know that. They are submitting that. We do not know that, my lord. We are absolutely amenable to what my lord suggested, what fell from my lord, that little bit in the park, little bit in the special officer's residence. I think it would suffice both parties, my lord. My submission.
And supervisor 5 hours was the duration of visitation right for a period of 5 hours.
My lord, last 6
Yes,
months, I have been last 6 months.
The act compelled, the situation compelled him to perform the depriving. It is not that for this.
Where is the park? Please give me.
Well, 1 hour, 1 hour. I could have understood.
1 hour.
No.
Well, Kali calls it.
Let it be 5 hours.
Well, time will be that.
I can direct that for 2 hours in that special officers and balance 3 hours in that park. What is?
My lord, can it be the opposite? 2 hours in the park and 3 hours in this.
Don't bargain with the court in that. Yes.
5 hours visitor, my lord, never seen. Well, I could understand the father is taking somewhere else, and this anonymity in such a position. This
my lord.
Yes.
It is not festive season. Only on Sunday it has been given.
The mother will enjoy with the child, my lord.
And till today, what is the duty performed by the father?
6 months I am deprived.
Yes, without paying, without looking the son for any manner.
Payment is a separate issue.
Yes.
I wish to pay. They are not taking the payment. Why not? That is a separate issue. Just because the child does not get attached to the father. No gift is taken. Na babar kache kichu nibi na.
Well, Kali calls it 5 hours.
I think will happen, Mr. Rai.
What is the
Nothing will happen.
So,
Yes.
all the mother is required to be made.
Father has to get the benefit of.
Yes, but the mother should be there.
Yes.
Mother should be there.
No.
Mother should be there, my lord.
Then let it be at the special officers.
Yeah. My lord, advance some report against the mother, my lord. Absolutely.
Right, then I'm not interfering with this, Ashut.
Advance report
Application under
against the
Article
my lord.
27 of the However, no order as to cause, urgent photostat certified copy.
Grateful, man.
Yes, thank you. Yes.
Item 54, my lord.
54 you have not mentioned.
My lord.
Extension.
It's urgent. It's just custody, my lord. Visitation has been denied, my lord.
Oh, I give you liberty to move before the vacation bench.
Puja's, my lord, visitation has been denied, my lord. Kindly allows.
Item number 54, leave is granted to the petitioner to move before the vacation bench. Yes. Yes, yes. Extension.
My lord, and for the petitioner, my lord, there is a stay subsisting till the end of September, my lord.
Where is the appeal service?
My lord, the other side is in the lower court, my lord, there has been a dismissal of a default on this stay during the subsistence of the stay, my lord. The stay is required to be
served upon the opposite party.
Sir,
pursuant to this direction passed.
My lord, yes, my lord.
Where is the appeal service, sir?
My lord, I'm not carrying, my lord.
Not today. Yes. Sure.
My lord, item 49, my lord, item 49. Just praying, there's some urgency, but it's actually asking for expeditious disposal. I'll be honest.
Item number 55 is a non-caveat matter, my lord. Is a non-caveat matter, my lord, and the plaintiff is required to be returned under personal appearance of the
Fourth, move before the vacation bench.
My lord,
third is the vacation bench. Which item?
37. Because I am impression it will be hard, but just I have received the latest order.
37. And your item is
49, my lord.
49, expeditious hearing.
Can you not wait? Building commercial suit, I'm getting a date every after 3 months.
Can you not
I know.
Come after the vacations. They have to transcribe. This has to be signed and uploaded. That's
my lord, item number 55 will remain in the list.
Grave urgency. Yes, yes.
My lord, item number
Yes, yes. All matters will remain in the list.
my lord, item number 55 is a non-caveat matter, my lord.
What is the urgency?
Urgency is my lord, the injunction has been granted whether the plaintiff is required to be returned under Order 7, Rule 10.
That can wait. Yes.
My lord, I have already filed.
Injunction cannot be stayed, sir.
No, my lord, the plaintiff,
Sir, injunction order cannot be stayed without serving the other side.
My lord, let there be an order for serving the notice upon the my lord.
There is no grave urgency.
My lord, there is a grave urgency because my lord, this deficit court fees in the matter, my lord. The matter is required to be my lord, required to be instituted upon payment of 50,000 court fees, my lord. Kindly consider this, my lord.
Please come after the vacation.
My lord, if this cannot be taken up, my lord, this side of vacation, my lord, I have already made an application for.
Before the vacation bench, I am giving you liberty. Item number
55.
55. Petitioner will be at liberty to move this matter before the vacation bench. Yes. Yes, Mr. Rai.
Page 56 is a suit for declaration and injunction. In such a suit, my lord, it was directed. Degree was passed. Page 54. My lord will find. And who was the party? State is the party, the collector. Appeal was preferred. The appellate court directed, my lord.
Yes.
To assess and to pay the damages for the purpose of using the said plot.
Yes. What is the impugned order?
Yes, impugned order, my lord, you shall find at page. This is order number 19th August 2025.
19th of August.
Yes.
2025.
My lord, if you lordship can turn to the second page. In third page, internal third page, the operating part of the judgment as follows.
Sir, a substantial sum is due from you.
It is not me. That is the problem. I am not a party. Executive engineer is directed to pay the. How I can pay? I put this to myself.
Where is the executive engineer directed to pay?
Yes.
Oh, is a public servant and as order is in past.
And for the implementation of the writ court's order, whether this maintainable, I put this to myself. Everyone is going away, my lord, putting me. I am not neither made a party in the proceedings. In a writ court proceedings, the writ court says, yes, you can consider the same. Now the writ court has...
No, you are not a party in the suit.
No. That your lordship will find from the degree itself. When it can turn to page 55. Who are the parties? State of West Bengal BLLO. ADM.
No, any acquisition proceeding was there
No, it was illegal.
for not paying compensation
Means,
amount.
that is the second argument. Whether in absence of any proceedings, whether any compensation can be paid. Apart from that, if there is a dispute regarding the loss and damages, it is required to be quantified by the court itself. That now, my lord, can you consider the executing court's order once, my lord?
Yes.
For what reasons in a order passed by the writ court should be implemented? That your lordship will find at page internal page 16. Before that, internal page 16.
Internal page 16.
Department is public servant has been passed by the attached its office of district judge Nadia. Tackle unwanted.
Passed by the writ court.
Yes, yes. That your lordship. Give me 1 minute time, my lord. Yes. If your lordship can return to
that is operating against you, Mr. Rai.
Yes, I could have.
Not challenge that.
No.
Where is the order passed by?
Mandamus appeal is pending.
Mandamus appeal is pending.
The court is of the that is why if your lordship can return to.
Where is the order of the writ court?
If your lordship can return to the
Mandamus appeal is pending, but you have not paid for stay.
No, stay application pending. That is why 1 minute, my lord.
Stay application is also pending.
Yes. My lord, can you turn to page internal page 10, page 17.
Internal page
10.
The 10 is the body of the application.
No,
where is the order?
Impute order. Of the impute order.
Oh, no. I want to see the order passed in the writ petition. Where is that?
Petition. Yes. It is there. আচ্ছা কিন্তু এটা তো আমার গ্রুপটা নেই না ওটার জন্য অসুবিধা হচ্ছে it is mentioned my lord in the order impute it is also mentioned
Ashun
and the writ court order
Item number 42, my lord.
What is the
Lord,
urgency?
my police help application has been rejected, my lord. But I am enjoying an injunction order, my lord, ad interim
Police
injunction.
self rejected.
Yes, my lord.
Yes.
And Lord, I am enjoying an ad interim injunction order, my lord.
Police
They are
self,
raising
with the
construction.
police self, what do you want?
My lord, if Lord,
Police help of an ad interim order of injunction.
yes, my lord.
Difficult. Madam, may I come after?
Madam, may I permit?
Lord, can you direct the service, my lord, at least?
To vacation.
Yes.
Lord, can you
Leave
direct
to-
the service, my lord,
Leave me
at
with
least, my lord?
Leave to move to vacation.